She has mentioned that at 10 o'clock, if the instruction doesn't come,
Huh.
the officer will appear at 2 p.m.
Yes.
So I do not know about anything about the instructions, but the matter may be taken up at 2.
Yes, it will be taken up at 2. Item 63 at 2, huh?
That compassionate appointment matter where he was appointed in the year 2017, salary has not been paid on the ground that finance has not cleared. Approval is not.
We'll take it up at 2.
Item 7.
7.
7. The accommodation. I'm for the petitioner.
Yes.
Hearing it, with the consent of the other parties. The outstation, can it be on 11 March?
Yes, yes. Item number 7, huh? On the request of the learned counsel for the petitioner, with the consent of the learned counsel for the respondent, list this matter again on the 11th of March. Yes.
Item numbers 8 to 14.
Huh.
Matter pertains to verification of the experience of certain candidates
Huh.
who are not allowed to sit in an examination conducted by APDCL.
Huh.
So that exercise is complete, but the records are voluminous. So we'll need to file individual affidavits. May I pray for some accommodation to this? I've informed the other sides.
How soon can you have it? Your convenience.
2 weeks time.
2 weeks. Mr. K. Pathak, learned counsel appearing for the APDCL, has submitted that the verification process has been completed and individual affidavits would be required to file regarding in each of the writ petitions, full stop. He has accordingly paid to be accommodated for a period of 2 weeks. The learned counsel for the petitioner does not object to the same but has prayed for an early date. Accordingly, list this matter again on 2 সপ্তাহ পিছত দিয়ক। Second of March? 2nd of March? Yes. You have, she's not, you have informed. Second.
Wait, please, Your Lordship, I beg to mention item number 34, Lordship. Pass over for the day, Lordship, and fix it on 16, Lordship. It's Monday.
At the request of the counsel for the petitioner, not objected to by the learned counsel appearing for the respondents. List this matter again on
Monday, 16th.
16th of February. Yes,
My dear Lordship, with concern of other things, Lordship, I beg to know item number 28, Lordship.
28.
Matter
Yes.
may be adjourned for the next any date, Lordship.
Learned counsel for the respondent.
Petitioner, Lordship.
Petitioner has prayed for an accommodation for the day. List again on. Yes. When do you want?
After 1 week, Lordship.
Not after 1 week. 18 মানত দিব পাৰে নেকি? ইয়াৰ মতে 18 মানত দিব পাৰে নেকি? 18th? 18th. Yes.
Lordship, I seek to mention item number 4.
4. Just a minute.
Your Lordship, I request.
Yes, tell us.
Your Lordship, kindly give 30-minute passover as my senior is on the way. He will be appearing shortly.
Okay. We'll take it up when he appears.
May I please, Your Lordship? Item number 56. After a harsh struggle, this matter is listed today for order correction. May I pray that matter may be taken up for upgradation? I'm paying for them.
56 is for orders.
The IA is filed for order correction.
What is the correction you want?
Lordship may kindly take up the matter.
Yeah. 56 ahi paise nai par.
I have tried several times. One day it was listed before another bench, again mentioned.
Is it a minor correction or something big?
No, minor.
Date correction, name correction,
No, Lordship.
section correction.
Order correction.
How can order correction be small?
Yes. Lordship may kindly come to page number 10.
10 of what?
Page number 10, order passed by your Lordship dated 10/12/2025. Now, Lordship may kindly come to paragraph number 3.
Yeah, I আছে.
I.
I do not pass 10-page orders. No? Yes.
Page number 10. Lordship may kindly peruse the paragraph number 3. The learned counsel for the petitioners has submitted that the OP number 2 had filed an FIR on him before the officer
Hmm.
is so and so, which culminated in CR case.
Huh.
It ought to have been the PRC case.
Heard the learned counsel.
After FIR lordship, it is not CR, it is PRC case. And
You-
again, and what order ought to have been passed, I have clearly written in my petition, which is at page number 5, paragraph number 2. That in paragraph number 2, I have
But
correctly.
without the PP, can we make that order? So you just need the words CR case to be substituted by the word
Substitute.
PR case,
Because
PRC case.
Because lordship has passed an stay order,
Huh.
one case has been stayed, CR case has been stayed. Because of this, I cannot produce this order.
Or some other CR case has been stayed.
Yes,
Hmm.
other CR case. Firstly, in paragraph number 3, it is mentioned.
You get the APP, will do it. Get someone from the APP, will do it. We'll have to record someone's presence for the state.
I have correctly written in paragraph number 2.
I understand, sir. I'm just saying, get us the APP so that we can do it in his presence.
Oh,
PP is on an.
yes, yes.
Lordship, I have the similar appeared in item number 57, Lordship. We have the PS case number and the.
56 or
father
57 to PPI lage mati di.
Well, item number 28 was mentioned by the petitioner, my lord.
Huh.
I have only, my lord, 18, I have problem, my lord. It was fixed on 18 February.
Huh.
And another, my case was fixed on 11th March, my lord. Then it will be 11 March, my lord.
You'll have to tell the petitioner that
Yes, yes, my lord, morning, I've date,
28 to 11 March ko di.
all my name will record, my lord.
And Mr. SK Mehdi
In-
for the
in the
for the
both-
respondents.
In both the cases.
One case,
There another case, I mentioned it, item 11, 7 also, my lord.
item 7 also. No, item 7 has not been mentioned. I think. Oh, 7. In both the cases.
Yes.
SK Mehdi for the 11 March ko di.
I love.
দুইটা 11 মাস করে ঠিক দেখি
There is one, my lord, there is one talk amongst us understanding. I said that this petition has come, I need some time for filing affidavit. Then he said, no, he wants to make a prayer for certain. Then
No,
now,
this was filed way back on 24th of January. So my respected senior has ample time, but he has not chose to file not any affidavit, your lordship.
today.
And your lordship, there are 140.
No, I do not see any orders passed in this IA. That is the difficulty.
This has come for the first time, your lordship.
Then how
in the-
could it file
97.
In the main petition, there are two orders. In the main petition, there
Still?
are two orders, WPC.
WPC can do?
Lordship made last order, my lord, on
297.
22 January.
No, sorry. 6016.
Yes.
আছে হাতে হাতে দিও। Why is the IA so big?
Not I, my lord. Yes,
Your
that's what, that's what. Today is 10th or today is 11th day.
No?
And I wanted to file the reply on this one and then my lord, 11th day today. And this is more than 300 pages. And kindly see this order, why I'm saying so. Order passed in writ petition, that's order dated 21 of January, my lord. He appeared on that day, my lord, and he was direct to file an affidavit and the matter has been fixed on 27th of this month.
So,
So I was under the impression he'll file an
have you
affidavit.
filed an affidavit in opposition in the?
He has not filed.
No, your lordship, I filed.
Meanwhile, he has filed IA. I was getting impression that it will come on 27th, my lord. I was mentally prepared, getting prepared for that.
Your lordship, I filed a stay vacating. There is a stay operating in.
What
this-
is the stay order?
Your lordship, if your lordship kindly take up my IA, I have annexed everything. Nothing has been concealed, your lordship.
Promotions
Yes, your-
without leave of the court.
yes, your lordship. And
So
there
the-
are 140 numbers of.
You are appearing for whom?
I'm appearing for the private respondents who have been
The
implicated.
leave has been granted to proceed with the leave of the court.
Yes, your lordship.
The proceeding part has to be done by the state respondent.
Right, your lordship.
No leave has been granted 2 years of date to file this interlocutory application.
That's fine.
State is not objecting to it. We'll have it on 26 to
Your
2026.
lordship, there are.
Complete your pleading, sir.
Your lordship, there are 140 numbers of posts and there are only 14 petitioners. And for this, they have been keeping this pending on the plea of one case or another since July last year, Your Lordship.
If it is necessary to fill up those posts during the pendency of the writ petition, then the official respondents would put up the same that we need to fill this up. We are ready to fill this up. Give us the leave. We'll consider.
Your Lordship, may I
Being on a
place it-
select list, being on a
May I
something
place
list is not your right to be
may I
promoted.
place it in this way, Your Lordship? The gradation list was published.
We have it on the 26th,
27th date is fixed. 26th, I am supposed to file the affidavit. Reply.
27th.
Yes.
We'll have it on the
That's very
27th.
clear,
sir.
my lord.
We are superseding others.
That's what.
Can it be before this? Because
Before?
ultimately, before 26.
No, we have fixed a date on 26 by the earlier order.
And after hearing the parties.
Oh, everybody was present here.
That can be.
Mr. So-and-so, for the newly implemented party submits that he has already been served copies of the writ petition and would like to file an affidavit in opposition that is not on record. Taking into account the above list matter again on 27/6. In the meantime,
No,
affidavits be exchanged.
Your Lordship, they have filed the affidavit. The state has filed their.
Can I? Can I prepone it?
On request of all the parties.
Yes, sir. By what time would you be able to file your reply? They are requesting for a preponement.
Okay. Lordship may fix my lord in
Is
that
it
case.
convenient for you?
Yes, give me the reasonable time so that I can.
Today is the 11th.
11th, my lord.
On 19 May.
19th Malaga, 19th Malaga.
19th, no, 19th, we have got 25 cases listed for hearing.
22nd? 22nd, my lord?
22nd or 26th? 26th already fixed.
22nd, 26th, my lord. One day, let them be happy, my
Not
lord.
22nd, 24th, huh?
26. 22nd.
No, 27th was the date. Fixed.
27. No hearing. date.
So make
Let
it-
be on a hearing. date.
It's all right. Let the matter finish for once for all, my lord. Every time we are coming to the court. we have
26th?
come to the court.
26.
Yes, done, done,
26th, did you?
done, my lord.
At the request of, with the consent of all the parties appearing in the matter, list again on 26th of February, although by an earlier order, the matter was required to be fixed on 27th. Full stop. Parties to complete their pleadings on or before 26th of February 2026. No further time would be given to any of the parties to have any documents on records thereafter.
Deeply.
Let us now do it.
Now, my lord, one thing. Please ask him whether he will take tea with me now. Please ask him. He doesn't take tea with me.
Have a cup of tea.
Surely, sir.
Next date. Mr. Sharma?
Lordship, in this matter, Lordship, initially I have taken the steps upon the private respondents. And Lordship, since the private respondent has not entered appearance into the matter, in the last occasion, Lordship, your honorable court has allowed me to take fresh steps upon the respondent number 5, 6, and 7, Lordship. Lordship,
7 and 8.
5, Lordship.
5, G. Bora Standing Council is appearing. 7 and 8 was the order, 28/11/2025. Are we reading the correct order?
7, 8.
Accordingly, the petitioner shall take fresh steps on 7 and 8 by registered AD
Lordship.
within 1 week.
Lordship, due to my mistake, Lordship, I failed to take these steps upon the
Ah,
response fresh steps.
Mr. D. Sharma, Learned Counsel, appearing for the petitioner has submitted that due to an inadvertence, the steps as required by the order dated 28/11/2025 could not be taken. Full stop. He prays for an accommodation of a week to take the necessary steps. The prayer is allowed. He may take, the petitioner is allowed to take steps by registered, by speed post on the respondent number 7 and 8 within a period, within 17th of February 2026. List the matter on. Just a minute. Let us complete the other. 17, 20. 20th of March.
Yes, sir.
Along with service report on the respondent number 7 and 8. Mr. appears for the respondent number. Ms. Sharma appears for the respondent number 1 and 3. Mr. Sharma undertakes to serve extra copies before 17th of March, February 2026.
Highly obliged.
Interim operating.
Highly
Adios, PPI is ready. something, IA can code. There is an IA where I had to quote the PRC, I had quote the CR case. So some other case is now under stay and his case is proceeding. We'll collect that.
No.
Heard Mr. So-and-so learned counsel appearing for the applicant, also heard Mr. K. Gogoi, learned PP. Full stop. The petitioner has submitted, the counsel for the petition applicant has submitted that the para number 3
Para.
of the order dated 10/12/2025.
Third para.
Para number third.
First.
Third para of the order dated 10/12/2025 should have read as. You'll take from here, huh? Page number 6 or more. A to A লিখে দিছো, huh? Go. That is the only correction.
No, Lordship. And
And?
third para, next paragraph, similarly, in place of CR, it is inserted PRC.
Here you have not given it.
Alternate wrong was done.
He further submits that the words CR appearing in para
Para number 1, 2, 3,
the last para.
4.
Complainant had, just don't write. Complainant had also filed a complaint case which is registered as CR.
CR, yes.
That should be CR case number 790.
No, Lordship. PRC case number 790, in fourth para, it ought to have been CR case number 164. I have
further
correctly
submits that
written, Lordship,
the-
in my petition.
You have not written about the fourth paragraph. That is the problem.
Statement this. Statement this. Yes. In place of CR, it ought to have been PRC, and in place of PRC, it ought to have been CR. That is the only correction. Lordship.
In the third paragraph, it should be PRC case number 164.
Yes.
In the third paragraph.
It should
It
be
should be
PRC
PRC.
case number 164. Oh, sorry,
And
PRC case
and
number
the fourth
790.
paragraph, instead of PRC, it should be CR case number 790.
No, Lordship. In place of CR case number 164, it should have been PRC case number 790. 790 of 2022. And in the fourth paragraph,
Once more. The learned counsel for the petitioner submitted that the OP number to file an FIR on so-and-so before the officer in charge, Boitamari Police Outpost, which culminated in
PRC
PRC case number.
790.
This should
of
be
2022.
790 of 2022. Wherein
Yes,
sufficient grounds and all that has come. Now the fourth paragraph.
Yes.
Learned counsel for the petitioner submits that 1 week after the filing of the aforesaid FIR, the complainant has also filed a complaint case which is registered as
CR case number 164.
2022. And then in the last part also some correction is required. No.
No, Lordship.
In the meantime, it is provided that proceedings in CR shall be kept in abeyance. That is correct?
Yes.
That is correct?
That is correct.
Cut out the order. Heard Mr. So-and-so, heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned Mr. K. Gogoi, learned PP appearing in the matter. The learned counsel for the petitioner submitted that the third paragraph of the order dated 10/12/2025 ought to have been quoted as A to A quote koribo. তাতে CR case number যেটা pencil দি উপর correct কৰিছো হেতু লিখিব ঠিক আছে he further submits that in the the fourth paragraph should have been quoted as he submits that there is a typographical error in putting the case numbers in the order dated 10/12/2025. Learned PP has gone through the records and has agreed that the case numbers are wrongly written. Stop. Accordingly, The prayer for modification of the order dated 10/12/2025 made by the applicant is allowed. The order dated 10/12/2025 shall now be read as. The entire order likhi, give the correct case numbers at the relevant portion. Okay?
I dispose lordship now.
I disposed of.
Matter may be fixed for hearing because very simple matter, only 5 minutes.
If we have not fixed the date on the earlier occasion, we will not fix it now. We said 3rd of
Probably it
February
was not-
2026, it
Because
will come
after
up.
not fixed,
Don't take a
lordship. So I
chance.
am praying
Yes,
for
next.
fixing a
Immediate.
a date, lordship. Fixing a date, lordship. Obliged.
3rd week of February, it's next week.
In respect
May
of
it please your
57
lordship.
lordship,
Here, lordship, the
Just a minute.
in respect of 57 lordship, Mr. B. Sharma is also appearing in this case, lordship. So lordship, tomorrow, lordship, medical emergency, he has come to the.
Okay. What is the correction that you wanted?
correction, lordship, father's name,
Correction.
Dilbar Khan, it was written Dilbar Khan instead of Dilbar Mia, and the PSK.
What does the
Correction.
cost title say?
Here, lordship, Dilbar, in my petition, lordship, it is Dilbar Mia, lordship. Actual name is Dilbar Mia, but it was written as Dilbar Khan.
Only in
P-
the cost title part, you need a correction from Khan to Mia.
Yes, lordship, and the PS case number, lordship, the order
PS case.
doesn't reflect the PS case number.
Tomorrow, Mr. Sharma is saying,
Lordship, it can be done, lordship, only the PS case number, inserting the PS case number, nothing else, lordship.
inserting PS case number where?
In the order sheet, lordship. Which case, lordship, it was charge sheet has submitted, but the PS case has not been mentioned.
Oh, white CS number. That is what you want.
Yes, lordship.
From where
PS
did you get it?
Lordship, the CS number is not required, lordship, in PS case, lordship, it is not reflected, lordship. Which PS case he has to appear before the court, lordship, that was not reflected. Although, lordship, I am, in my petition, I also have stated.
Mr. Gogoi,
Lordship,
We can go.
we heard
I
Mr.
think lordship, item 66.
Oh, no.
I think.
Heard Mr. So-and-so learned counsel appearing for the applicant, also heard Mr. K. Gogoi, learned counsel appearing for, learned PP. Full stop, the learned counsel for the petitioner has submitted that in the order dated
Will have here somebody.
21/1/2026. The inadvertently, the PS case number in which the petitioner, had to appear before the learned trial court was not quoted. He submits that the said PS case number is
Boroma PS case number 42/2005 corresponding to GR case number 301/2025.
no, go slow.
Lordship, Boroma PS case number 42/2025 corresponding to GR case number 301/25.
Paleva? Okay.
In pair portion,
They have mentioned.
pair portion they have mentioned.
Yes. The learned counsel for the applicant also submits that there is a typographical error in as much as the name of the father of the petitioner in the cost title has been reflected as Delbor
Khan instead of Dilbar.
instead of Delbor Mia. In the bail application filed, this court finds that the petitioner has been described as the son of Delbor Mia.
It was in the original petition.
Yes, yes, there.
No, in the bail petition, we are looking into it.
Lots.
It is Delbor Mia
Lordship,
in the bail petition,
lordship.
not in the I.
Lots.
Bail petition. Delbor Mia and not Delbor Khan, full stop. The learned PP has gone to the bail petition on record N. This court also observes that this name of the father of the petitioner is recorded as Delbor Mia in the bail petition. Full stop. Accordingly, the order dated 21/1/2026 shall now be read as. When you type out from here itself, change this to Delbor Mia, right? And here you write the concern petitioner to appear before the concerned trial court in connection with whatever case number was given to, okay? To pay for regulars. This order shall be read as a part of the earlier order dated 21/1/2026 passed in AB number 2980 of 2025. The registry shall verify in the CS as to whether the correct name of the petitioner's father is reflected in the CIS as is recorded in the anticipatory bill petition. I disposed of.
Highly obliged.
Thank you, sir.
In case of item 66, I have a pair of this.
Hmm.
In this matter, my daughter make as a part of lossy here. B Sharma is appearing, the medical emergency lossy.
Tomorrow.
Tomorrow also, tomorrow. Tomorrow at 2 p.m. or any
And,
time.
let the council be here. We don't have the council. Once we take up the matter, we'll
I will be not here.
not required. Mr. K. Gogoi, Learned Counsel, it will be item 66. Mr. K. Gogoi, Learned Counsel, a learned PP appearing in the matter has submitted that the records of the matter are available with Mr. B. Sharma and an accommodation will be given for today. So that the matter can be listed tomorrow. Accordingly, list tomorrow
Tomorrow at 2 p.m.
at 2 p.m. Tomorrow at 2, list the matter tomorrow. We'll take it up at 2.
Lossy.
Don't type out the order. We'll have to take the consent of the applicant. Tomorrow. Next.
Lordship may pass over this matter for the time being, Lordship. Miss M. Bhattacharjee, she is appearing in this matter, Lordship.
After something. Yeah. Photo आना नहीं है तुम्हें. So it's.
Madam, password for timing.
Correct.
May to lordship.
I was a delivery for orders. Hit with 2. You multiply to the item. Okay. Yes.
Confession about the matter, the father of the prisoner died in the year 2005.
This matter was dismissed for default. They filed IA and restored process.
So dismissed on merit. Yes, sir.
There are some
2005.
high court order also the prisoner has directed to me.
Sorry?
There was some high court order also in favor of the petitioner, but that was not followed by the department, by the SL.
When was the first?
First was within time, Lordship. It was in the year 2007.
Just a minute.
Just 34.
Page 30.
4.
4 years, sir. Why the orders of the court were not complied with?
After that,
Have you filed an affidavit in opposition? You are appearing the matter.
Lordship, after dismissal or default, Lordship, we
Or you
don't have
you did not retain the
No, no,
records
no,
after
sir.
that. Huh?
we don't have the brief now.
That is what you did not retain the brief after that.
Lordship.
Yes, sir, you have to give him a copy if you
Yes,
want
sir.
to proceed. But tell us at this distant point of time,
And some
was the
private
age at that
parties are
point
also
of
there,
time?
Lordship.
2017, what is the age?
now he is 14.
Now he is
14. 14.
And some Lordship, another aspect is some private parties are also there. Notices to go to them also.
about the restoration. Would you like to have your instructions? Taking the steps again by a
Sir,
person who
I shall
is,
take the steps because he's interested.
no, he is
Interested, I
interested,
made
but
him.
then his very interest would show that he is not so hard pressed that he would require compassion from this court.
Lordship, after 2005, Lordship, the other time.
Is it not?
I shall take the steps. Somehow.
This matter was, Vicky, this matter was
2017.
restored by an order dated. When was it restored by order?
Last
dated?
order, Lordship.
Last order. The IA.
2/2/2026.
Lordship.
Yes.
Take it, yeah.
26,
I opened the-
February 26.
Huh?
February 26. He's on.
Was restored on 2/2/2026, full stop. The Learned Counsel appearing for the,
I am Lordship for the irrigation department.
or the irrigation department has submitted that he would be
Lordship, they are
requiring
also-
a second copy of the, He would require an extra copy of the writ petition since the records of the brief were not retained after dismissal of the matter on an earlier date. Similar plea is made by Ms. Sharma, learned counsel appearing for
2 and 3.
2 and 3.
In that case, I'll say I am for 1 and 4.
List this matter again on March or DDP on 27th of March.
No.
27th of March, allowing the learned counsel for the petitioner to serve extra copies on the learned counsel appearing for the respondents.
And notice period has to go to the private respondents. Lordship.
There we beg to differ
Lordship.
because the names have been struck off by a certain order of
Lordship.
this court.
Obliged, Lordship.
Obliged.
I think this one, this better after some time.
After some time soon.
Well, today clearly because I'm having some other matters also.
Ah.
So can it be on a at 2 minutes?
At 2.
At 2
We
minutes.
will not say at 2, we will say not before 2.
Before 2. I will tell you. Yeah.
Hmm.
Hello, the feedback is on legs matter after something.
After some time, at a heavy production, matter more door to connect.
In this case, Lordship, Mr.
Hello, I'm for.
No difficulty, we'll come back in 2 minutes.
In this case, Mr. B. Gogoi will appear. Item number 15 is. After some
We'll
time.
come back in 2 minutes. Next to deal. After this.
16 Lordship, I'm for the respondent Lordship.
Yes.
16.
May I please, Your Lordship? Malad, it is, Malad, we are challenging the provincialization order of the respondent number 6 and 7, Malad. Matter related to provincialization. On the ground of seniority, Malad. Petitioner has been appointed as an English teacher and at the very inception, Malad, that Malad appointment order which has been issued by the SMC, Malad. At the very inception, it has been written therein that he has been appointed as an Malad English teacher. Thereafter, Malad, the respondent number 7 is Hindi teacher, Malad. She is junior to me. And her service was provincialized, Malad. My service was not provincialized.
You are appearing for?
Lordship, I am appearing for respondent number, private respondent number, Lordship, 6 and 7.
You want to make submissions only on law?
Lordship,
Do you want to make submissions only on the records available before this case? Do you want to make submissions only on the basis of the writ petition and the law? We will not take any papers over the counter. We don't have an affidavit in opposition. Have you filed one?
Lordship, I want to submit.
From 2021, you were served the
Lordship,
writ petition on
We have filed
2012-2023.
we have filed Ukalat number on 24/06/2024, Lordship.
2 years down the line, 1.5 years down the line, you want to file an affidavit in opposition now.
Lordship.
Who appears for the education department? Heard the learned counsel for the petitioner. Learned counsel appearing for the respondent number 6 and 7 pray for some time to file their affidavit in opposition.
Lordship.
the same may be done on or before 24th of February 2026. Petitioner may file the reply to the same within a week thereafter. Marshal section. Huh? List the matter again on 23rd of March, along with the pleadings filed by the contesting parties. The state respondents have not filed any affidavit in opposition, and there is none to represent the department today. The affidavit in opposition by the respondent authorities named on behalf of the Department of School Education be filed
Respondent
on or before what time did we see?
2 and 3.
Till what date did we give you time?
24/2, Lordship.
On or before 24th of February 2026, failing which this court will be constrained to impose costs on the state respondents for not cooperating with the adjudication of the matter.
Oblige. But I'm appealing for the AST similar. I need some instructions on this matter. May I pray to fix it in the first week of March, not inconvenient.
You have also not filed your affidavit in
My lord,
opposition.
my lord,
We will only go through the writ petition.
My lord, we'll do it in the meantime, my lord.
You do it on or before 23rd of February 2026.
My lord,
Failing which will again impose costs if it is not done by 23rd
My
of
lord.
February.
my lord.
What is the matter regarding?
My lord, they were contractual, the petitioner was a contractual employee. He was arrested. So he was released from the contract. Now he want reinstatement. We said that we can take you back, but not as a reinstatement, re-employment as a fresh contract. That is the issue. See, they said, it has to be.
Why don't you go for a fresh contract now?
No, I will lose all my consequential benefit, madam. I have
In
joined,
contractual labor, in a contractual driver case,
there was no any.
it will be according to the contract.
No, there was no any contract. They have appointed me by issuing advertisement.
Where is the appointment order?
My lord, by giving a notice, my lord.
Where is the appointment order?
Page number 25 is,
The appointment order, madam.
there is a notice, by notice 620 people are appointed, my lord. They have appointed 620 people. And page number 27.
Just a minute. What is page 29? What is this?
My lord, STC has already, similar security person, they have reinstated, my lord. This honorable court has already been decided.
She says you have reinstated others.
I have to examine. I have to go through this. May not be similar, my lord. If it's similar, we'll take the same.
My lord, similar situated person.
Which judgment?
My Hiren Gauhati. Paragraph number 13.
Where is the order of termination?
Page number 33, my lord.
So I think you have to relook into we'll give you the time. But have you seen the third last line of page 33? The
Yes,
penultimate paragraph.
Yes.
He was under police custody for more than 48 hours. Does his contractual service deemed to be dismissed as per 6(4)?
I have not understood the language. Let me take the
No,
explanation.
when something is not understood, let us put it aside.
So, like, I'll come up with appropriate instructions and affidavit.
I
And if my learned friend says that if the similarly situated persons are already taken care of, it will be following the same.
So when do you want it?
And your lordship, please fix a date on 24th.
23rd, we are, if you want to file an affidavit.
Pardon?
If you want to file an affidavit by 23rd.
My lord.
Otherwise, we are fixing it on the 2nd of March. 1 day prior.
March, my lord, Dole Utsav, my lord, I will not be here.
Dole is 3rd and 4th.
No, from 2nd, this time.
6th of March.
6th of March.
Ms. So-and-so, learned counsel appears for the petitioner. Mr. A. Sumo, learned counsel appears for the Transport Corporation, for the Assam State Transport Corporation. The challenge in this order, challenge in this petition is to the order dated 24th of September 2019, by which the contractual service of the petitioner was deemed to be dismissed as per Rule 6(4) of the Assam Service within bracket Discipline and Appeal List 1964, since he was under police custody for more than 48 hours. The learned counsel for the petitioner has submitted that similarly situated persons have been reinstated in service. Mr. Chomo has sought for an accommodation to have his instructions. List the matter again on the 6th of March.
Well, I'll file my affidavit also.
List the matter again on the 6th of March 2026, on which date the matter will be taken up for disposal. The ASTC shall be at liberty to file their affidavit in opposition on or before the 23rd of February 2026. Full stop. Affidavit filed after 23rd of 2026 shall be accepted only on payment of cost of ₹3,000 payable to the District Legal Aid Services Authority. Give that one, the District Legal Aid Services. The petitioner would be at liberty to file reply prior to the next date of listing. Yes.
Well, these are the cases of one bank and similar employees, 4 employees, my lord. They have not been paid with their retirement benefits and area salaries. Well, in the first case, if lordship takes up the first case, that is the case number 515022.
Yes.
This lady, if lordship can come to the page number 6, my lord. Here's the calculation. Page number 6, there is a table. In this table, my lord, these are the non-payment. She retired, my lord, in the meantime. And out of this 5,62,000, they have paid 1 lakh in the meantime. Therefore, the total due is 4,62,578. This is the case, my lord. It is a cooperative bank. And the managing director was also arrested and put to custody for months together for committing financial fraud. They have taken a stand that bank is not making profit. But my lord, the fact is contrary, because of the fact that the bank has, your lordship can come to page 22, my lord.
They have an objection in the affidavit in opposition regarding.
That is not maintainable. My lord, after the BCCI judgments, my lord, I will show the judgments, my lord. In 2015, the BCCI judgments and I have given the list. And Janet Jayapal, after these 2 judgments, my lord, BCCI judgment is G Telefilms and BCCI. This judgment is a constitution bench judgment. It says, my lord, that if it may not be a state, but if it discharges public functions, then it is amenable to the jurisdiction.
And if it charges public function, even in that case, if the dispute is a private one between the bank and the employee,
This is not
would it still be a?
Yes, my lord. So far as
still lies what we want to know.
my lord may peruse the judgment rendered in the Janet Jayapal 2015-16 SSC 530.
What does it say?
Taking the cue from the BCCI judgments.
What did it say?
May I read?
that if it is a question of salary, termination,
My lord,
appointment.
same,
still
same,
should-
same thing it has, it's a trust, my lord. Lordship, may,
I don't have a copy. You retain the copy, you are asking me to read
my lord,
something
my
from
lord,
where?
my lord may take up.
If you give me that, what will you read from?
I'm from, read my tab.
Hmm?
Nowadays, your lordship is equipped with many things, so I thought I can say.
Is that a reason to put us to discomfort?
No, no.
No. Okay. Can you tell us?
I have marked the paragraphs, my lord, inside. Which one did you? In that case also, it was a dispute between the employee and the employer.
What was the issue here? The issue here?
He was a teacher in a deemed university under a trust. That is also a private body. But it was governed by the Tamil Nadu Trust Act. Here it is a bank governed by the Cooperative Act. They discharges public duty. By they accept public deposits and gives loan.
Did they approach the tribunal also?
Well, in this particular case, this lady filed an application before the labor court.
Then?
And labor court ordered, labor court said that you pay the amount.
Then?
Then they paid 1 lakh rupees and requested that they would pay the remaining amount later on. But they did not. Page 27, Annexure 6.
Joint discussion to be held at 23
Pardon?
2004.
Pardon me, Lord.
What is this?
Which page you are reading?
27?
Yes, Lord.
This is not an order.
No, this is not an order, but they considered that we are supposed to give this money. Immediately we will pay 1 lakh and they paid the 1 lakh, but remaining amount was not paid.
Once you agitated it before there, why not there again?
My lord, we approached there. They considered that we are yet to
So
pay.
now, when they did not adhere to it, to their agreement, when they, to their
We are not
concession.
leaving aside for a while the maintainability issue. If lordship says that this is an admitted case, that they have to pay me this amount, out of which they paid also a portion. The remaining they have not paid. This managing director who filed this counter affidavit, he was arrested by the police and ED
For filing the affidavit.
No, for causing huge financial misappropriation to the bank. And kindly see, they have taken a stand that the bank is facing loss, but she pays, my lord, 22, my lord.
Acha, tell us this, in your affidavit in paragraph 35, you have said financial resources of the state is the chief funding source. You say it is not. Why do you say it is not a state? Why do you say we do not have the jurisdiction to?
Finally,
You are appealing for the?
property bank.
So tell us why you say it is not a state.
My lord, finally, see the paragraph 9, Your Honor.
Paragraph 9. She approached the Labor Commission
Yes.
and you gave a
Undertaking.
undertaking there that now we'll pay this much and then we'll pay later on. So even for an admitted amount, she has to go to the labor court and not to the writ court when you are not being able to justify why your bank is not state. Are you denying that she is entitled to the pensionary benefits?
I'm not denying.
If it is, if you cannot argue that it is not a state, why do you say it is not a state?
And this is a judgment of the same bank.
Yeah.
Concerning the same bank, private retirement benefit not paid has been adjudicated by this court. This is a reported judgment, I suppose. I give the citations also. This is a reported judgment, slip number.
Yes, have you filed any appeal against this order?
No, my lord,
2017, no.
this attained its penalty.
Tell us something. Deposit of that in the bank to pay. Why?
AID, under AID,
Under the?
AID, Reserve Bank.
I am not understanding your submission, madam. Yes, heard Mr. H. Omol under counsel appearing for the petition. Also heard Miss. Your name, madam?
Yes, pardon me.
Yes, Praveen under counsel appearing for the respondent number. One, two, 1 and 2. Mr. Swenso appears for the respondent number 3 and 4. Who appears for 5? Who appears for 5?
No, madam, nowadays there is no administrator. Earlier, Reserve Bank was appointing an administrator. After the arrest of the MD, Reserve Bank had taken the administration of the bank
Now,
by
someone-
appointing an administrator.
Now?
Now, madam, there is board of directors.
Okay. Mr. Order counsel for the petitioner, Mr. Yasoma has submitted that now there is no administrator appointed by the RBI Gauhati, and therefore the presence of respondent number 5 in the petition would not be necessary. The claim in this petition is 2. The pending salary and other retirement benefits amounting to rupees 562,578, 5,62,578 to the petitioner, along with an interest of 12% per annum since superannuation till actual realization. Full stop. The case of the petitioner is that she had been appointed in the respondent bank as a
Office assistant
that she was a permanent employee of the respondent bank, and she was appointed on 12/6/1989 and retired on 28/2/2018 from the post of office assistant. Full stop. The learned counsel for the learned counsel for the petitioner said that the salary of the petitioner had been paid intermittently for a few years prior to the petitioner's date of superannuation.
Yes.
Several representations had been filed by the writ petitioner praying for the benefits. The tabular form of the benefits which the petitioner claims is at para
Para 3, page 6.
3 of the writ petition, and the
Page
same
6.
is reproduced herein below for a ready reference. Full stop. The petitioner had thereafter approached the Assistant Labour Commissioner Kamrup, Metro Gauhati,
Para 4, my lord.
where after admitting the claim of the petitioner, comma, the bank paid a sum of rupees 1 lakh only to the petitioner on 11th of October 2019, and a representation was made by the bank that since the bank was incurring financial loss, therefore the rest of the amount would be paid to the petitioner in the following year. However, no such amount was paid. The petitioner had earlier approached this court by filing WPC number 1080 of 2022, which was withdrawn with the liberty to approach this court afresh. The said liberty having been granted, the petitioner is before this court with the prayers as aforesaid. The respondent bank has filed an affidavit in opposition where the claim of the petitioner to be entitled to the emoluments as reflected in the table have not been denied, and it has rather been admitted that a sum of rupees 1 lakh had already been paid. Full stop. The affidavit in opposition also asserts that the correct approach would have been to the Labour Court under Section 33 within bracket capital C within bracket 2 of the Industrial Disputes Act for recovery of our pending dues. And an attempt has been made to project before this court that the respondent bank is not a state as defined in Article 12 of the Constitution of India, and therefore the bank would not be amenable to the writ jurisdiction of this court. Full stop. Responding to the aforesaid submission regarding the amenability to the writ jurisdiction of this court, the learned counsel for the petitioner, Mr. Somua, has placed reliance on the judgment of the apex court passed in JENET JEYAPOUL Janet Jayapal versus SRM University and others, reported in 2015. 16 Supreme Court cases 530, where the apex court had held that when an organization discharges public duties, an aggrieved party can seek a public remedy under Article 226. In that particular case, the respondent was an university and the dispute was between the employer and the employee regarding termination of services. Mr. Somua has submitted that drawing a line from the aforesaid case, since the dispute in this case is regarding payment of undisputed emoluments which had accrued to the petitioner before her superannuation and even after her superannuation as pensionary benefits, the respondent bank would be amenable to the writ jurisdiction of this court. Mr. Chomua has also placed reliance on an order dated 23/6/2017 passed by this court in WPC number 2193 of 2017, where the same same respondent bank was involved in a matter of a disciplinary proceeding with regard to the petitioner therein, full stop. Next paragraph, having heard the learned counsel for the parties and having duly considered the judgments placed on record, placed before this court by the learned counsel for the petitioner, this court is of the opinion that when the amounts claimed by the petitioner remain undisputed by the respondent authorities, comma, the respondent authorities would be liable to pay the aforesaid amounts to the petitioner. Full stop. It is noticed that the petitioner had retired in the year 2018 and had approached the Assistant Labor Commissioner, before whom the respondent bank had admitted the amount to be paid and had actually paid up rupees 1 lakh by keeping the rest of the amount, by promising to pay the rest of the amount by the next year. Full stop. The attempt in the writ petition by filing this affidavit in opposition appears to be more to resist the litigation itself than to justify the denial of payment to the writ petitioner. Full stop. In the aforesaid circumstances and in the aforesaid peculiar circumstances of this case, this court directs the respondent number one and two to take immediate steps for dispersal of the undisputed amount of rupees 4 lakhs. What was it? $4,62,578 to the petitioner within a period of 3 months from the date of receipt of a certified copy of this order. Stop. The petitioner Mr. Soma has submitted that the petitioner is a retired person and within a period of 3 months from the date of receipt of a certified copy of this order. Full stop. The petition is accordingly disposed of, no costs.
Other matters also similar, but the amount is different.
Kindly give a list. Kindly give a list of the date of appointment, the date of retirement, the amounts involved, and the undertaking before the Labor Commissioner.
No, there was no undertaking before the Labor Commission.
So we'll have to change that part. But give the other details.
Well, just
The
before
date of appointment.
during the lunch, I'll prepare and give.
Oh, please give it to me. Please give it to the court master.
Oh, my lord. My lord, all the petitions are disposed.
All petitions are disposed of.
I'm deeply obliged.
May I please the lordship?
Hmm.
My lord, an order is under challenge, my lord. My lord may be pleased to find that order is at page 47.
Page 47.
7.
Again. Yes. Have you seen page 46?
My lord.
The last paragraph. Kindly read it silently.
Yes, my lord. Therefore.
No,
sir,
read it silently.
my lord.
Yes. Now we'll read 47.
In pursuance of the letter number dated by the laboratory code number so and so, submitted by the food analyst to the government of Assam regarding the damage and fungus infested PM Poshan rice.
They wanted to dispose of the rice. Then what happened?
My lord, they want to dispose of the rice, but my lord may kindly turn to the next page. I had been held to be liable and directed to be pay the cost, my lord, as the my lord in charge headmaster of the said school. In fact, my lord, my case is that, my lord, at that relevant period of time, I was not holding the, my lord, charge of the office of the headmaster. my lord.
Prior to that time? Prior to when it
Prior
was?
to that time, I was there. Prior to, but the incident and which has been alleged, my lord, is
The
not,
discovery of the
my lord,
infested rice.
my lord, rice is no
That
doubt.
rice had to be there for some time.
No, my lord, I am not disputing that the rice is not damaged. Rice is damaged.
It will not be damaged overnight.
No, it is not possible, my lord.
Was that rice received
My lord.
at a point of time when you were the in charge?
No, that fact I'm bringing, my lord. Those
Please.
other annexures are also there, my lord. Now, in which part, my lord, I am agree, my lord, I am reading the last paragraph. In pursuance of the inquiry report number dated so and so of the circle officer of so and so regarding the infested 45 quintals of PM Rosan rice so and so was compared with the existing stock of grains, and there is a clear discrepancy of the. Meanwhile, the superintendent of the Tinthenia High Madrasa so and so has not utilized the so and so as per the norms are not reported in the time. As per the letter number dated, laboratory number dated, submitted by the food analyst to the so and so, the sample does not conform to the prescribed standard as per the food safety and standard regulations and unsafe according to section so and so of the food safety and standard. Act 2006.
Your argument was on the basis of the authority of the deputy commissioner and the inspector of schools to impose punishment upon you.
My lord,
That is your case.
That is my case, my lord, which for the purpose, my lord, which I am not the person to be held to be responsible and guilty, my lord.
From where does this rice come?
My lord, it is a PM Posan. I think this is the, my lord, mission director has issued under the Sarva Shiksha Abhijan mission, my lord, for that midday meal scheme, my lord, midday meal scheme. My lord.
So you are challenging this order of
Yes,
the
because,
mission
my lord,
director.
because, my lord, may kindly I am troubling my lordship with the last paragraph, my lord. Therefore, Mrs. Amina Khatun, superintendent of the Tinthenia High Madrasa, is directed to bear the equal quantity of the quality rice so and so, and now cost and distribute to the students within 12th of December 2022 in presence of Sri Divyajyoti Pegu, DAO, District Agriculture, maybe PM Pusan SSL Lakhimpur, BO Bipuria Education Block, President so and so of the school, and submit a detailed report for the same to the undersigned. Now, my lord, when we move the petition, there is an interim protection had been provided to me, my lord. Now, if my lord, I would like to take my lordship's attention, my lord, to the page number 26, annexure 1, my lord. My lord, may kindly note the date, my lord, 3/6/2022, my lord. This is a letter addressed by the petitioner to the inspector of schools, my lord, prayer for the earned leave for the purpose of Hajj, along with the headquarters station leave. With reference to the subject cited above, I have the honor to inform you that I want to go to Mecca, Saudi Arabia for the Hajj purpose with effect from so and so to for 52 days.
Mr. Bhia,
My lord.
if the authority to impose the penalty or impose the recovery on you is not there,
My lord.
we stop there. They will have to have their own inquiry as to what led to that damage, whether you are responsible for it and whether it needs to be recovered from you. Your case is I am not an employee of the Sarva Shiksha Abhijan.
No, my lord.
I am not their employee.
No.
They had given me some items.
My lord.
It has been misused, misappropriated,
That is-
damaged.
No.
Then it has to be reported to the appropriate authority. Who will cause an inquiry and then it can be recovered or not recovered.
My lord.
It will not be the deputy commissioner or the inspector of schools.
My lord.
Although they may be a part of the SSA, working as nodal officers or DMCs, etc.
My lord.
That is your case?
Yes,
Yes, sir. Tell us your authority. Huh? Who has filed? And you are for the SEC. What does the deputy commissioner say? Where do you have the authority to recover? Huh? Where do you have the authority to recover the rice from him as a penalty without an inquiry? Was he a part to it? Was he given a hearing? Is it there in the? Hmm? Respondent number 3, yes. Huh? Huh? Hmm. 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 We are not saying that she may be guilty or she may not be guilty. Who is the appropriate authority to conduct the inquiry against her to impose the recovery, madam? That is what we are asking you. Read court would interfere when an inappropriate, unauthorized person takes up a disciplinary proceeding against the person raising a grievance before this court. Had it to be done by, yes, it was supposed to be done by Mr. Kaushik. Whether she discharged her functions as a in charge of headmaster for those periods, whether she failed to give away the rice, whether she had it stocked in a manner which it was not supposed to be stocked. And then, yes, the rice was damaged because of her. Therefore, it will be recovered from her and the fresh rice would be bought and distributed. And look at that order. It says that you buy the rice and you distribute it to students. So what he could not eat yesterday, the student could not eat. He has to now eat today itself. Can he do that? Can he eat backlog? Cannot eat backlog. He has the authority. Otherwise, we are setting aside that order, leaving it upon the appointing authority or the disciplinary authority to act in cooperation with the district authorities who had supplied the rice, have an inquiry, give him a fair opportunity, take a decision. Whether he was required to be held responsible for only for the month of April and May, since from June he is gone to Hajj. He could not have taken care of the rice during June and July. So you cannot recover that part of it. April and May. What was the extent of his negligence in it? And therefore, what amount needs to be recovered and who was there in June and July? What did he do? The district nodal officer. So he will make a complaint to the appropriate authority who can work against him. That this is what we have found in the inquiry. You are the disciplinary authority. We need the money. Do something. And what does the DC says? You buy it out of your pocket.
My lord.
Mr. Bhuyan,
My lord.
inquiry has to be there.
No, my lord,
Appropriate authority would have acted.
No, my lord, as the rice has been damaged. So, my lord, I am not saying that there should be some negligence on the part of not only me, my lord, other persons are
That
holding.
is what we have seen. April,
Yes.
May, June, July.
My
You were not there in
I
June
am
and
not
July.
there. No,
April,
no,
May, you were there.
my lord.
Now, whether the
Now,
rice was there available in April and May,
Yes, yes,
whether it led
my lord, the quantity of rice which is on stock, is it from the month of April or after that, my lord? That is also required to be inquired into, my lord. Whether
the extent of our negligence has to be inquired into by the appropriate authority. Yes, madam, appropriate authority. Who is the appropriate? Sir, would you still like to file an affidavit in opposition or should we? This has to go. This order has to go. After that, you make your complaint to the disciplinary authority that this is what our inquiry says. Proper inquiry will be held. Under the Assam Discipline Appeal Rules, recovery is one of the modes if any loss has been caused to the government. Is it not? And why should only be recovery and distribution of rice? Dismissal from service. Either dismissal from service or a medal for squeezing out of the discipline proceeding, whatever you want to give. We'll dispose it off. No use keeping it pending because he's enjoying a stay. Nothing is happening.
Similar.
Huh?
Petitioner is similar.
We see the petitioner in you.
My lord.
Yes, heard Mr. A.R. Mihan, learned counsel appearing for the petitioner. Also heard. Mr. Bora for. Who? You are appearing for? 8. Who is 8?
Lord, the inserts.
During the time when she was not
My
there.
lord.
The June, July part. And Mr. B. Kaushik, learned counsel appearing for the Department of School Education. The challenge in this writ petition is to the order dated 7/12/2022, by which the Deputy Commissioner cum District Nodal Officer under the PM Poshan Scheme for the district of Lakhimpur had required the petitioner, who was the superintendent of the Tinthenia High Madrasa, to bear the equal quantity of quality rice of 45 quintals at her own cost and distribute it to the students within 12th of December 2022 in the presence of the officials deputed for implementation of the Prime Minister Poshan Scheme. Stop. The case as reflected in the writ petition is that the petitioner had prayed, the petitioner while working as the in charge of the Tinthenia High Madrasa had prayed for leave, for earned leave
52.
to go to Makkah, Saudi Arabia with effect from 10/6/2022 to 31/7/2022. Full stop. Based on a newspaper report. Where is that newspaper report?
Lord, that report is not available in the petition, Lord, but it is reflected in the affidavit.
Okay, just a minute.
There are
Ten.
four.
In view of the earned leave granted to the petitioner by the order dated 21/6/2022, by another order dated 11th of July 2022, the respondent number, your respondent number what, sir? 8 had been allowed to hold the charge of the superintendent during the period of absence of the petitioner. Full stop. On her return from Hajj, the petitioner was served with a show cause notice dated 6/8/2022, which relied upon a news broadcasted on 4/8/2022 in a particular news channel that approximately 95 bags of PM Poshan rice were found unused, damaged and full of insects in the school godown premises. The petitioner was charged of negligence of duty. The petitioner filed her reply to the show cause
24/8/2020.
on 24/8/2022, whereby she had given some justifications. However, the office of the state nodal officer, however, the mission director SS, who is also the state nodal officer, PM Poshan Assam, requested the Secretary of the Government of Assam in the Department of Secondary Education to cause an inquiry and take necessary action against the petitioner herein as per rule deemed fit. Full stop. The petitioner filed a representation before the Secretary of the Government of Assam on 31/10/2022 with copies to the mission director and the Deputy Commissioner Lakhimpur. Full stop. By the order dated 7/12/2022, the Office of the Deputy Commissioner and District Nodal Officer PM Poshan Scheme had required the required the damaged rice of 45 quintals to be disposed of and to be disposed of full stop by another order of the same date. The petitioner was required to bear the expenses of the equal quantity of quality rice of 44 quintals at her own cost and distribute it to the students within 12th of December 2022, full stop. This order is under challenge. Mr. A.R. Bhuyan, Learned Counsel, appearing for the petitioner, has submitted that the petitioner, assuming though not admitting that the certain quantity of rice had suffered infestation and damage in the school premises, during the period from April, May, June, and July, the petitioner was admittedly on leave during the month of June and July, and therefore no negligence could have been imputed upon her for the aforesaid period. The Learned Counsel for the petitioner has further submitted that simply because some amount of damaged rice had been recovered from the school premises, the authorities would not be empowered to impose the penalty sought to be imposed by the order dated 7/12/2022 without holding a detailed inquiry and without allowing the writ petitioner to participate in the same. Mr. A.R. Bhuyan and Counsel has further submitted that the Deputy Commissioner and District Nodal Officer PM portion is neither the disciplinary authority nor the appointing authority of the petitioner, and therefore imposition of penalties by such authorities on the petitioner is wholly uncalled for in law. Full stop. Mr. A.R. Bhuyan submits that the reasons for the damage caused to the rice, if any, had to be done by a proper inquiry. And if there are allegations sought to be leveled regarding negligence or other misconduct on the part of the petitioner, she was required to have been given a notice by the appropriate disciplinary or appointing authority. And only after having come to a conclusion regarding the extent of her involvement in negligence or misconduct causing the damage to the rice, orders of penalty or recovery could have been imposed upon her. Full stop. Mr. A.R. Bhuyan, the Learned Counsel for the petitioner, has submitted that the impugned order dated 7/12/2022 bearing number DMC/SSA/L/MDA/complaint/part 2/2017/20/20-20/701 therefore requires the interference of this court. The Learned Counsel, Ms. So-and-so, Learned Counsel, appearing for the respondent, for the Deputy Commissioner, Deputy Commissioner Lakhimpur has submitted that the Deputy Commissioner is also the nodal officer of the for the implementation of the PM portion scheme, and therefore when it was seen that there was actual damage caused to rice stocked up in the godown of the school, appropriate action as deemed fit was taken by the concerned nodal officer in the discharge of his official duties. Full stop. Since the rice had suffered damage and had not been distributed among the students, it was deemed fit to direct the petitioner, who was responsible as per the inquiry report conducted through the circle officer, to pay up for such damage cost, and also to ensure that the children who were the beneficiaries of that scheme should be able to avail the benefits. Full stop. The Learned Counsel, appearing for the Sarva Shiksha Abhijan Mission, Mr. S. Bora, has submitted that the Deputy Commissioner is also the District Nodal Officer, and it was under instructions of the Assam Sarva Shiksha Abhijan Mission Director that the inquiry had been caused into by the District Nodal Officer, and when fault was found with the petitioner for having allowed the rice to be damaged by negligence, if not by misconduct, comma, appropriate orders had been passed by the district nodal officer. Full stop. The learned counsel is preparing for the respondent number 8 has submitted. What do you say, sir? And Ahmed, what do you say?
That time I poorly given the charge during that period.
From June to July.
They mean that prior.
Mr. N. Ahmed, learned counsel appearing for the respondent number 8 has submitted that though it is admitted that he was given the charge of superintendent from the period for June and July, as reflected in the official orders, the rice available in the godown was already damaged, and he cannot and his client cannot be held responsible for the same. Full stop. Mr. B. Kaushik, on a pointed query by this court, has submitted that the disciplinary and appointing authority of the petitioner is the Director of Secondary Education. Full stop. The learned counsel appearing for the Department of School Education has submitted that even in the event the order dated 7/12/2022 is found to have been passed by an authority which did not have the which did not wield the powers of the disciplinary or the appointing authority, comma, the fact remains that huge amount of rice had been found to have been damaged in a particular school, comma, which rice was required to be distributed among the students in accordance with the PM portion scheme, and therefore an inquiry would definitely be required to find out the persons responsible for causing such loss and damage. Full stop. He, however, candidly admits that it is the disciplinary or the appointing authority only which can cause the relevant inquiry with the cooperation of the SSA of the authorities of the Sarva Shiksha Abhijan and the district authorities concerned to find out the actual cause of the damage and then to proceed to decide whether the same requires to be recovered from persons who had charge over such rice. Full stop. We have considered this court has considered the submissions made at bar and also has considered the records of this case. Full stop. Since now it is an admitted position that the appropriate decision for fixing the responsibility of the alleged loss of rights would lie upon the disciplinary appointing authority of the petitioner, comma, the order dated 7/12/2022 issued by the nodal officer of the service district nodal officer for PM Pushan and Deputy Commissioner from Lakhimpur is hereby set aside to the extent that it required the petitioner to bear the equal quantity and quality of rice 45 quintals at her own cost and distribute it to the students within a particular frame of time. Full stop. This court notices that by the initial order the notices were issued, comma, the operation of the said order had been stayed. Full stop. It is, however, provided that the respondent number, who is the director? Respondent number? 4. That the respondent number 1 and 2 would be at liberty to cause an inquiry into the alleged damage of the rice, which was reflected in the reports submitted by the district nodal, the district nodal officer and the circle officer, if such complaints are so forwarded by the office of the mission director Sarva Shiksha Abhijan to the respondent number 1 and 2 for taking appropriate action. This court notices that such a request had already been made by the communication dated
20th of October. 20th of Annexure 8, Milord, page 44.
Page 44 had already been made by the order by the communication dated 20th of October 2022, addressed to the Secretary of the Government of Assam, with copies being forwarded to the Inspector of Schools LDC for information and necessary action. It is unfortunate that there is nothing on record to show that the Department of School Education had initiated any action on the aforesaid request of the district mission of the mission director, SSA, when the matter involved the damage caused to rice meant for students under the Prime Minister Portion Scheme. Full stop. The aforesaid respondent number 1 and 2 shall exercise their discretion to proceed with the inquiry as requested by the mission director within a period of 1 month from the date of receipt of a certified copy of this order. From 1 month from the date of receipt of a copy of this order, which Mr. B. Kaushik, Learned Standing Council, assures the court will be supplied to them at the earliest possible. The mission director, SSA, may also pursue the matter with the respondent number 1 and 2. Full stop. With petition disposed of, no costs. Or we can impose the cost of 45 quintals. No.
My lord, only my limited prayer, my lord. In that inquiry, my lord, they will follow the Assam Services Discipline and Appeal rules.
No, the inquiry will not follow that.
No,
If a disciplinary action is required to be taken against you, that inquiry will follow it. Now they will try to find out what was the extent of damage, who might have been responsible. That is a preliminary inquiry where you might not even given be a notice. Once the preliminary inquiry holds that yes, it was during that point of time, then the charges will be framed. Mr. Kaushik is conversant.
No, my lord, another prayer, my lord, by an order dated, my lord, 24/6/2024, there is a direction to dispose of this decomposed rice.
All orders passed with, one more sentence. I was forgetting. All interim orders passed earlier shall merge with this present order.
No, my lord.
Respondents would be at liberty to dispose of the said rice as required by this court on the earlier occasion. If the rice is disposed of, how will they find out?
No, my lord,
Which rice was for which month?
No, my lord, what is the problem? The problem is that the rice is in such a bad stage, my lord. The educational environment and atmosphere is also now very difficult.
It is still in the school.
Yes, my lord, it is still in the school and the smell is very disturbing, my lord.
Should be recording the order that they are required to remove it. What do you do when NDPS is caught? When some narcotics is caught, what is done? Production and sampling package and the rest of it, what is done?
They can seize and keep in.
Slowly it will become something which is very popular in the villages. If you allow it to keep rotting like that. Yes?
So that rice, my lord, can be removed from this.
The respondents should also be required to remove the damaged rice from the school premises. And if it is required to be stored, store it inside their offices in seal packs. Keep it inside the Inspector of Schools office. He will ensure disposal.
Obliged, deeply obliged.
Yes, we'll make the corrections as required. We'll just noted down what is to be.
Obliged.
Yes.
Wait, please, well, this is the matter where the division bench had given a finding I had completed 23 years of service. Based on which I said that I am entitled to pension because I am completed 20 years of service. My lord had heard this matter.
And then there was there was something regarding whether he was put under suspension and then it was revoked or not. Yes.
Suspension or
Yesterday, the local head officer got some documents by us. Will this matter come up next week now?
Tomorrow. They got them yesterday because the case was fixed today.
No problem.
We'll put it up tomorrow so that you can get the documents today.
the division bench finding that they could not produce the record. The single judge asked them to produce the record, they could not produce the record. Now suddenly they say that they have the records.
See, whatever is there. Secondly, my lord, will satisfy them. Then if they are entitled, there is no bar in paying. If they are not entitled, they cannot ask for that payment. Let us see, my lord. Let us examine it and then.
Tomorrow.
My lord, next week, my lord. Let it be parted, no problem.
2 o'clock.
Tomorrow, my lord.
Tomorrow 2 o'clock.
By 1 o'clock. The more you haggle, the more we can.
No, it's up to the.
When do you want to tell us the date?
Next week, my lord.
Friday, if not tomorrow, Friday.
We'll have it on 21st. Nice big Saturday.
My lord.
14th. General Counsel appearing for the bank has submitted that the bank has been able to trace out some of the records. And the same would be placed before this court on the next date of listing. What are those records regarding?
Regarding.
Very confidential.
Not seen.
No, is it very confidential?
No. You can.
The said records be produced before this court on the 17th of February 2026. Oh, 17th of February. On the 18th of February 2026. With an advance copy to the counsel for the petitioner.
Good.
Good stuff. No further dates would be granted in this matter. Yes.
Briefly of that,
18th. Huh?
Treated as a part-head.
It is coming up before this bench without being treated as a part head, is it not? If you, otherwise we'll have to take a list there, how many part heads. Yes, sir.
So, yeah.
No difficulty.
But this petitioner before lawsuit is a copyist working with a foreigner's tribunal matter. He is working against a section vacant post.
Huh.
But still he has not been regularized. Also, kindly see, he was appointed since 98 against various vacancies, but by annexure 5 page 20, my lord, he was appointed as copyist against a section vacant post, my lord.
From 17, why has it not happened? Yes, madam?
Lordship, we received the instruction.
From 2017, now instructions. दे रहा है, दुरुस्त है.
Actually, he was engaged as a copyist in a contractual basis. Lordship. And these posts are personal to the respective MR, casual fixed pay, similarly placed workers, and will be abolished as soon as the incumbents relinquish the posts in any manner. And the minimum of the pay scale has already been given to him with allowances also, Lordship. Lordship may turn the pages to the office order.
Which order?
Government of Assam Political B Department Office Order.
14/11/2025.
Yes, Lordship. 14/11/2025. In pursuance of Finance Department's notification dated 14/5/2025, the following employees of foreigners tribunals who have been approved of payment of minimum of the pay scale as per notification so and so dated 3/10/2019 and are hereby allowed 50% of admissible house rent allowance as per extant norms. Lordship, this case, he is not entitled for regularization or regular scale of pay, Lordship. He is entitled as per Upendas, he is entitled for the minimum of the pay scale that he is receiving.
That he has received.
Yes,
Where
Lordship.
is it? We will give you some time to file your affidavit in this matter as to what is his pay that is now being given.
Lordship.
What are the allowances now being given? Whether Upendas has been made applicable to him in letter and spirit, if it has been done. Regularization, sir.
But these are working as a section vacant post.
Could be.
Sanction vacant.
Now,
post.
if
It
he's,
is a
if
contractual basis post.
he's working against a sanctioned vacant post after a due selection and all that, somewhere the consideration of for regularization of service, will it not come in? Would
Lordship,
Upendas be the only solution? If he has completed 10 years of service in a regular sanctioned vacant post,
But Lordship, in the Lordship, it is
from the year 1999,
Lordship, after Upenda's regularization cannot be given to him, Lordship, because this and the post is also a contractual basis post. The
File
vacant
your
foreign
affidavit.
tribunals are temporary establishment.
file your affidavit.
Yes, Lord.
We'll take a call on that.
Yeah.
Now, since he's been given the minimum scale of pay, when should it be have been given? From when should it have been given? What are the allowances he's missing out? Have your instructions. If the petitioner is satisfied with what now comes to him, you ask for the stars, you get the moon. People are satisfied at times. So you start wait for regularization, he may be satisfied with what comes to him. Is it no?
I've tried to
2017
contact him, but
onwards, huh?
I could not contact him, but I tried to contact him.
We'll allow her to file the affidavit. In the meantime, have a letter sent. And if he may not be in touch because the benefits have now started flowing.
Yeah, if perhaps he's getting the minimum scale of payment. Perhaps
Try
he
to
has-
find out. Have your instruction. Miss U. Sharma, Learned Counsel, appearing for the respondent, has placed before this court the instructions forwarded to her on 5/2/2026, whereby it has been asserted that the petitioner has been granted the minimum scale of pay, the pay in the minimum scale. And he has also been granted 50% house rent allowances, etc. Full stop. The prayer in the repetition was for regularization of service, which Miss Sharma has asserted would not be possible in view of the judgment rendered by this court in Upenda's case, reported in so and so. Mr. Ayat Sekia, Learned Counsel appearing for the petitioner, has also sought for an accommodation. We have instructions from his clients regarding the payment of the benefits asserted today. Mr. Place this matter again on 25th,
Not from 25, madam.
20,
26 or 27. madam.
27th
Right.
of February 2026, by which time the Ms. Sharma shall ensure that the affidavit is brought on record, and Mr. Ayat Sekia would also have his instructions from the petitioner. For that. Hmm. Yes.
Diesel worship. Worship, I have prepared a small compilation. Matter relates to fixation of seniority, Malak. What has happened in this case, Malak? A gradation list was prepared by combining the appointees of two different batches. Now, here is a case, Malak, where the selection process were different for the petitioners and private respondents. However, the results were declared on the same date, and they joined their service on the same date. Now, while deciding the seniority, now they have made the combined list, putting the petitioners at bottom of private respondents. So that is the grievance of the petitioners here. Now, they are giving various reference to various laws, Malak, why they have done it. Now, in the meantime, Malak, the objections filed by the petitioners before the commissioner's secretary, he has decided this issue. I have put it in compilation, Malak. It is at page 31. Yes, Malak, it is at page 31 of the compilation. Now, my lord, the Commissioner of Industries, while deciding one such objection, it says that with reference to subject above, I would like to inform you that she's Abdul Barmia and Dipesh Sharma, that is the present two petitioners, junior assistant of your establishment, been paid this office for resolve the gradation list of junior assistant issued by you. So,
Okay, that is settled position.
yes. So now, if two persons are recommended by Public Service Commission, here they are not recommended by the Public Service Commission. Ma'am. This is not a public service.
They are recommended by whom?
This is, my lord,
Let us go by the simple law. There are two recruitment processes, one held in January, one held in June. Both this, the select list of both these recruitment processes are forwarded to the authorities. They make appointments. All of you join on the same day. The person where the advertisement was earlier and whose select selection took place earlier, even if taken place together also,
That's,
would not matter because the advertisement was earlier.
that's right.
And therefore they would remain senior.
That is my question. That is my.
That is what they have said.
But my lord,
That
if
the
they
person
appeal-
who participated earlier would remain earlier.
Yes, my lord. But while my lord, the affidavit filed by the department is otherwise,
Huh.
and they have not settled the issue, although the commissioner secretary has decided. Now, my lord, in view of this order, may I pray now, instead of going into a lot of water has flown in the meantime. So they can make a fresh gradation, prepare a fresh gradation in view of this, because
But
commissioner.
already I think the respondents have been promoted and they have joined. That is what you said.
Not yet.
Then entire DPC has to be redone.
My lord, it has to be corrected, gradation.
Once the gradation list is corrected, the DPC has to be redone.
That process has not initiated.
Who appears from the department? No, you need not move because he is yet to acquaint himself with the facts. We will have to take it from here. You have to acquaint yourself. We'll record your name. Yes, madam, what do you say?
Lordship, may I just take you to the straight away to the rules? What does the rules say? Page 89. Lordship has 4876, item 24.
We will see if we are required to hear you at all. Yes. We will, of course, hear you on the question of law, but the facts we can gather like we are gathering. Yes.
Lordship, I will go straight to the law first. It's page 89. This is the rule that governs service. Assam Ministerial District Establishment Service Rules.
Yes.
Lordship, these are 309 rules. Lordship, the position that we are concerned with is cadre lower division assistant. Page 91, 3-6. Lordship has that. Then Lordship straight away goes to page 93. Which is the recruitment process. If Lordship has 91, 6, the recruitment starts. And I'm straight away taking you to 6, subclause 6, which is the lower division assistant. Lordship has page 93? Yes. Mary, by direct recruitment on the basis of competitive examination to be conducted by the Deputy Commissioner at the beginning of each year, unless otherwise directed by the government in this behalf, provided that in the office of so-and-so not concerned. Lordship, now the note. And the note is important. At the beginning of each calendar year, the Deputy Commissioner shall call for applications to fill up temporary vacancies of any kind which are likely to occur in the course of the year in their respective establishments. On receipt of application by a specific date, a test shall be conducted and a list of all candidates suitable for appointment to the post of lower division assistant shall be prepared in order of merit by the Deputy Commissioner. The list shall remain valid for 1 year unless it's exhausted earlier and on such list having been prepared every year. Lordship, it contemplates one list pursuant to an application process. Now, Lordship may kindly go to page 95, which deals with seniority.
Yes.
11. 95, right at the bottom, 11. In the lower division cadre, which is what we are concerned with, the seniority shall be according to the date of appointment. If the person joined the appointment within 15 days of receipt of the order of appointment, provided in case of persons prevented not concerned, Your Lordship. 96, Your Lordship, and the most relevant rule is the second paragraph. Page 96, second paragraph.
Same date, position.
Yes. When, however, Lordship has, when, however, more than one person are appointed on the same date, their inter-se seniority shall be determined according to the position in the merit list, prepared by the Deputy Commissioner, as mentioned in the note of subclause 6.6, which I read out. So the rule is very clear. If I'm appointed on the same date, then my seniority will be according to what my merit is. And that is exactly what has happened, Your Lordship. And Lordship,
are there two different,
Batches.
two different selection processes?
Different selections. That is
Not
it.
selection process, different dates of the same process. One batch was appointed one
No,
time.
no, what I am asking is, there is a selection, there is an advertisement in January and there is an advertisement in May. Is
That's
that the
right.
case?
That's right.
February.
January and
Yeah,
February.
two different
Then the
advertisements.
January persons and the February persons, they would have different
Dates
calling
of-
letters.
Possibly.
The
Yes.
the selection body may be
Dates of
comprising
written
of this.
test
Written
and the
test.
written
There'll be
test.
there'll be
Two different dates. Yes,
select
yes,
lists.
yes, your
So
lord.
there'll be two different select lists.
Yes.
This law that we have read at
Your
page
lordship, there is
96,
no different select list. There may have been different dates.
there
Now
will be,
that,
there'll be
that,
two
There are
different
different
merit lists.
select merit lists also.
There'll be two different
there's
merit lists for
select
each
lists
of the
there.
processes.
there is one merit list.
No, no, different
That is,
select
that
lists
is the whole
there.
thing.
Where is that merit list? Can
The
we have
merit
it?
list is what they're impugning, which is basically page 38.
There are different select lists also.
Yeah, we'll come to you, madam. We'll come back to you.
Well,
We are just understanding what, are we conversant with the facts?
Page 38.
Ah,
Lordship may look at page 81. Let me show you the sequence. Just to be clear.
which
Page 81 first. It will be the additional our affidavit in opposition.
Notice for general candidates, huh? General notice for candidates, huh?
Yes. Page 81, your lordship.
That is
It
what
is
we
for
are saying.
general information for the candidate.
There are
appears.
two advertisements.
Yes, your lordship.
And they hold one selection.
Yes. And after that, what happens, your lordship, is page 38.
Where are the advertisements?
Lordship, they are not on record.
my lord, I have put this, put the advertisement on compilation. My lord.
Ah,
It is at page 6. My lord.
page 6.
Opportunity, sir. No.
No, we'll
I-
ensure that copies are given to
Yes, yes.
everybody before we come to a decision.
Recorded nothing, no, I'm just no.
No, we are just going through because it has been given to us. We'll ensure that everybody has a copy and a chance to answer to everything that is placed before us, before we take it. This is the first advertisement. Where is the second advertisement? The second advertisement was for the private respondents, is it?
Yes, yes.
Do we have
9
that?
to 16.
Ah, yes. No. Do we have your advertisement? The ones that your plans have.
On record, please.
But do you have a copy of it? Can it be made available?
I do have. Thank you.
Is it given in the compilation?
During the
Ah,
compilation.
madam. So let us do it this way.
Extra-
We'll need both the advertisements because we'll need to decide whether it was two different selection processes, which for convenience was taken up in a joint process, and therefore the select list prepared jointly. Can it stand the scrutiny of law? Because some people had applied on the earlier selection process. Is it not? So now, if they had done a selection process combined only for the sake of convenience, would it still affect the settled law that someone who has participated in an earlier selection would remain senior? If this combination does not affect that law, she has a case. And if because of the selection process, that law is affected and now everybody has to be taken on their own merit, you have a case. So therefore, we'll need all the relevant documents.
Yeah.
You have all the copies. You have the advertisements.
Yes, my lord.
You have the select lists.
Yes.
These have been given here. Could it be difficult to convert it into an affidavit or something which can be placed before this court with advanced copies to the?
Yes.
Also, advanced copies of, also copies of the repetition to the standing counsel for the department. And at a convenient date, with all replies have been given, we'll take it up for disposal. When? Tell us. When will you file the affidavit? How much time? 7 days. Because this is not an opposition or a new assertion. These are only documents which either will be a true document
to
or
us.
will be a
Fine.
forged one. If it is forged, let us know. Yes, once the copy is given, has the department filed any affidavit?
Yes.
Then give Mr. Bora a PDF set of everything that is on record. Mr. Bora, a PDF set would do of all the documents. All the affidavits which have already been got on record, the petitioner must be having. You have copies of, everybody has a copy of the affidavits filed by the other, 1, 2, and 3, then 4 and 5, and rejoinder. Everybody has, you have a copy. Heard Ms. P. Chakraborty, learned counsel, is paying for the petitioner. Also heard Ms. G. Goswami, learned counsel, is
4
paying
and
for
5,
the
Your Lordship.
4 and 5,
In item
and
24.
Mr. Nair, you are paying for it together.
Item number 25, respondents free and.
Huh? WTC numbers. Mr. D. Bora, learned counsel, appears for the state of Assam in the Department of Industries and Commerce. Good stop. Mr. Bora has submitted that he would be requiring a set of the pleadings since the earlier records have not been made available to him and are not available with him. Ms. P. Chakraborty, counsel for the petitioner, has agreed to supply the pleadings on record as well as the affidavit proposed to be filed by her to Mr. D. Bora on or before 23rd of February 2026. Ms. Chakraborty is also allowed to file an additional affidavit to bring on record certain documents which were placed before this court in the form of a brief compilation with advance copies to the counsels appearing for the respondents. The matter shall again be listed on date in March. 12th of March is available with us, or 10th of March.
Just my NAD.
12th of March. On 12th of March, by which on which date an attempt would be made to dispose of the writ petition.
Obliged.
Deed obliged.
Yes.
My lord, for the first time I am appearing in this matter, my lord, for respondent number 4. And my lord, copy also not with us.
Served upon you. No copy with you
No,
of the writ petition.
No, my lord. First time I am appearing.
Yes, Mr. Bina, you are taking steps without copies of the writ petition.
No, no, my lord, initially we did, sir, but perhaps, my lord, it has been misplaced.
Lost in
Okay.
transit. Lost in transit.
My lord, the case is very simple, my lord. My provincialization has been withdrawn with a ground, my lord, which is not at all tenable under the.
Why was it
2007.
withdrawn?
My lord, the order is impugned, my lord, is at page 45, my lord.
Page 45.
My lord.
Yes.
The provincialization order in respect of so and so subject teacher logic and philosophy of so and so high school under Bongaigaon district issued by memo number is hereby withdrawn as the feasibility report is not found in the feasibility report issued by so and so, so and so, so and so. Initially, my lord, I was provincialized, my lord. Now, once
As the subject concerned is not found in the feasibility report, is what should have been written.
it is not required under the law, my lord. It had later on, my lord, it had been clarified also by the Assam Higher Secondary Education Council. My lord, by way of a letter regarding,
Dated?
my lord, according,
Where do we find that letter?
my lord, that letter is at page, my lord, annexure 6, page 44, my lord. With reference to the subject cited above, I am directed to inform you that the feasibility report forwarded to the government earlier does not mean according permission in the subject public subjects from the council. So the council will not entertain to send any report again to the government as per your application. However, the council will accord permission as soon as the posts are created by the government and appointments in the concerned subject.
Did
of
your,
A. My
did
lord.
your subject have the permission?
Yes, yes, my lord.
Where is the permission?
My lord, my case, my lord, is that by following the due procedure of law, after examining and scrutinizing all the particulars, my lord, I had been provincialized in that subject. Now, my lord, once I had been provincialized, my lord knows, my lord, that I have enjoyed the status of a government servant, full-fledged. Now, my lord, can the director, my lord, but just a stroke of a pen can withdraw, my lord.
Yes,
the main case, my
Mr. Kaushik, can you do it?
No, but this withdrawal order has already been interfered by this honorable court.
That is there.
And
what happened?
they subsequently, my lord, in terms of the direction that was given by this honorable court, my lord, page 46 is the order.
Page 50.
Page 46, the order starts from page 46.
The High Court order.
High
Yes,
Court.
yes, my lord.
Done.
On
Then
this
thereafter
honorable
what did you
court-
do?
And my lord will kindly see page 48, paragraph 5, 6, and 7, my lord. More particularly, paragraph 7, my lord. Here, my lord, your lordship finds, as such, the court observed that the respondent in the secondary education department shall take appropriate steps regarding provincialization of services. Now, thereafter, following this order, my lord, in compliance with this order, the petitioner has been provincialized under the 2017 Act, that is page 51. So this is in compliance with the
under the 2017 Act, my lord.
that was what was directed by the
My lord, this honorable court, my lord, my lord, from my limited understanding, my lord, this honorable court has held that this Act of 2017 has been held to be ultra virus, my lord. No, my lord.
11.
11, my lord. Now 11 is held to be ultra virus, but my lord, while the Act was surviving, my lord, then my service was
Did
provincialized.
did you assail this part of the order?
No,
of the
no,
learned
we
single
did
judge
not.
that
My lord.
in accordance with law,
My lord.
17 is there,
My lord, my lord.
11 is gone.
My lord, with all respect, my lord, may I be permitted to read over that part, my lord? It says, my lord, though the Assam Venture Educational Institution Provincialization of Services Act 2011 as amended was declared ultra virus and unconstitutional by the judgment and order dated passed by the division bench of this court in so and so, the state government in the education department has brought into the Assam Education so and so Act of 2017 with effect from 11/4/2017. As such, the court observed that the respondent in the secondary education department shall take appropriate steps regarding provincialization of service of the petitioner in accordance with law as per his entitlement only. Now, my lord, this honorable court has never issued a mandamus directing that my provincialization should be, my lord, under the 2017 Act.
The withdrawal of your provincialization was
Interfered with.
Court notices 2011 is already gone.
My
There is a 17 Act. Yes,
Yes,
consider him.
No, my lord, that is
As
correct.
regard
That
provincialization,
would be asking the court to
review the
spell out as if from the LDA level to the commissioner level, when they put up notes, this would mean this sentence will mean this sentence.
No, my lord,
Cannot be done, Mr.
my lord, with all respect to the order passed by
With
this.
greater respect, Mr.
My
Bhuya,
lord,
when
my
the
lord.
court notices that 2011 is gone
My
and
lord.
there is only 2017,
under which I
respondents do it. What greater respect can we have but to
No,
say
with
that
all,
when something is not there, can it be considered?
my lord, my understanding may be, my lord, wrong, my lord. May be wrong, my lord, but the thing, my lord, is that, my lord, this honorable court once interfered with my cancellation of the withdrawal order, my lord.
Only to the extent
My lord.
that it was done without a
Without
notice.
hearing.
That
Is
is
it not?
correct. Without the observation of the latter part, my lord.
And thereafter,
My lord. Needless to say that the respondents in the secondary education
as
department.
such, is so-and-so being in violation of the principle of natural
Well.
justice is hereby set aside and quashed.
My lord.
Is it not?
My lord.
Now,
And paragraph
2011
9.
is not there. Now, this is a very unique situation in the state of Assam.
My lord.
Someone started in 2011, could not complete, under 17. Some people are accepting it. Something did not start in 2011, should have started, was done in 17. People are saying, take me back to 11.
My lord,
Fact remains, today, even if we direct them to do it under the 2011 Act,
my lord.
how can they? Under what?
My
That
lord,
law is not there.
Is it not erased?
My lord, my lord.
If you ask me to put something before my father today for his signature, my school report,
No,
can
no,
I?
No, that cannot be.
Cannot.
My lord, may I pray?
It has to be done by my
May I pray, my lord?
uncle.
The challenge made to the 2017 Act, my lordship knows, my lord. And that challenge has been assailed to the Honorable Apex Court also, my lord. That Apex Court, there are some direction had been issued in certain cases, my lord, regarding the benefits. Should
Are
be
you one of
extended.
them?
No, my lord, I
Are
am
you one
not
of
the,
them?
I am not
When
the.
I say you, I mean,
My lord, only thing is that, my lord, may I pray for a little accommodation, my lord, to, my lord, go through that order, my lord, if that can come.
in
some
the
respect.
meantime, you are enjoying 2011
My lord,
benefits.
my lord. But my lord, it has been very, my lord,
A
once
burden on the state,
provincialized.
huh?
Once
Huh?
provincial, my lord, may kindly.
No,
appreciate
he
one
would
thing.
not be enjoying anything extra under the 11 at 7 except that OPS and what? No, even not the
No,
OPS.
no,
What?
no, no.
What would he be enjoying?
Under the 2017 Act.
Tutor.
Tutor.
He may become a tutor now. He's a
pay.
teacher now, he'll become a tutor.
And he
No,
gets a
I'm-
fixed pay.
No, I
because
am
of
demoted, I
being
am
a-
demoted. my lord.
You have not been, you would be.
My lord, the financial benefit is lesser.
You would be demoted if we allow it to happen.
My lord. Now, my lord, may I pray?
Basically, not the designation, but the financial implication.
My lord.
Huh. If he's not entitled, if he was not entitled under 2011 Act, why not give him a notice and withdraw it and finish it? The only fault was a notice.
In fact, that was the paragraph 8.
Hmm?
Paragraph 8 of the earlier judgment.
If the petitioner is not
been done.
entitled for, go ahead to send this letter. And this is only a communication.
Yes, sir.
What is he challenging?
My lord, the order of withdrawal of provincialization.
It has again been withdrawn.
No, in this petition, my lord, my challenge is that 4/2/2021, 2017 provincialization order, my lord, because it had been
Yes,
given
challenge
effect.
page 51.
My lord.
Page
Page
51.
51, the provincialization order.
And it is under stay.
It is understood.
Not much time, Mr. Abhi.
My lord, situation is very.
Not much time.
And my lord, this order, the finding of this honorable court at paragraph 7, it was based on the, as the act was not then, there cannot be a mandamus under that act.
But you also cannot take away everything that you did. That was the.
But that has not been challenged. This order has attained finality.
Can it be done under the 17 Act, under the 11 Act again?
My lord.
Can it be done?
My lord, because, my lord, there is an order passed by this honorable court also, my lordship knows, my lord, that once there is a recommendation under the 11 Act, if there is no any executive order is passed, then also deemed to be provincialized. Now, here is a case, my lord, wherein my service has already
If
been
there is
provincialized.
if there is an appointment letter in favor of a particular person, it is found that he was not qualified.
Qualified.
Does he continue in
No, my lord,
service,
that-
or with a notice he goes?
No, my lord, that if there is a fraud or cheating or some.
Nothing done, nothing done. We all believe that graduation was required, so it was a BSc. Now we find out that no, it should have been a BA. So you were not qualified on that day to teach social studies. Suppose.
My lord.
But he is appointed. Now, since he did not have the original qualification,
My lord.
what is to be done?
No,
Give
my
him a
lord,
notice and withdraw the appointment.
No, my lord, for that, at least the principle of natural, because it will be a panel action against a person, my lord.
That is
So
what we are,
therefore, the
that is
principle of natural justice will come into
that is
play.
what you are saying. That is what you
My
are
lord,
saying.
my lord.
See, the court took care not to reinstate you under the 2011 Act.
Yes. Though they withdraw.
Simply setting it at naught.
My lord.
Finishing it there, we would have understood the intention
is-
to let you continue under the 2011 Act. But the moment 2017 is introduced, the court is of the opinion that you need to be reconsidered. The act already gone, whatever done under it, gone in your particular case. It has to be under 17. Nothing wrong.
If the order would have stopped in paragraph 6, my lord, it would have been restoration of the provincialization.
But the court intended that it should
And-
again be
yes.
reevaluated under the 17 Act.
My lord,
And the finding is very categorical.
When Mr. Yeah.
my lord, I'm just praying for a little accommodation, my lord, that if some respect can be done.
A little has now become almost 4 weeks.
My lord,
Because prior to 4 weeks, we are full.
my lord.
When anybody is seeking a little, we'll have at least 4 weeks.
Highly
No,
obliged.
may have at least 4 weeks. 9th. 9th of
My
March.
lord, my lord.
9th of March. Kindly give us, kindly show us how.
I can be restored back to 2011. Well,
As of today, bit difficult.
obliged, my lord.
Obliged.
কোন দিন বলে কে বল? 26 2টা বজাত বিলটো দিলাম বিলটো ডিক্টেট কৰি দিম আৰু কি থাকিলে আজি মানে ডিক্টেশ্যন কি থাকিলে
May I please your lordship?
Yes.
My lord, I beg to take your lordship indulgence, my lord. Out of turn, my lord, I'll pray. Item number 50 of today's list, my lord, daily list. My lord, we are instructed that the grievance of the petitioner, my lord, are being addressed by the respondent authority. Therefore, at this stage, my lord, we would like to withdraw, my lord, with liberty to file leave of patient arising.
Now, the counsel appearing for the petitioner has submitted that he is under instructions not to present this petition in the present form and to withdraw the same with the liberty to file afresh if the necessity so arises. The Subordinate Counsel appearing for the respondents does not object to the same. Accordingly, writ petition is closed as withdrawn with liberty to approach this court again if the necessity so arises.
Highly obliged. Highly.
Yes. Why? Huh?
2019 matter either Friday
Mr.
or
Roy
Monday.
has business in other court.
Monday can leave him. Monday.
One issue is whether this.
Ah.
I understand it goes to
Okay. 16th.
Deeply obliged.
Item number 6.
6.
Sooner the better. 16th. 2. Maintaining 2. Acha. You have filed it.
Yes.
What is it? Appointed lodging. The posting. Then.
10th of March. Prior to that, we are having 16, 18 cases fixed by us. 21st. 21st, yes. 21st will come. This matter again on the 21st of February 2026 at the consent of the Learned Counsel for the parties, on which day the matter shall be taken up for disposal. One five. Yes, sir.
Lordship. Lordship, the petitioner were appointed as a grade 4 employee under the Joint Director Health Service, my lord. In the year.
Have you gone through that division bench order?
Yes, my lord. Yes, covered matter, my lord. I have.
Not covered.
Yeah, according to my lord, moving on, Goalpara, there was a proper Advertisement.
Only for 2 districts it has come. And the rest of the districts, it is.
Others, nobody has approached the division bench, the challenge in the order of the land is free of other districts. It's been considered on that point also. So there was a selective, there was advertisement.
This is item number 15.
15, my lord.
You can show that there is advertisement in the petition.
Then it will be covered, then this case is covered by the single bench judgment.
Then it will be another.
Under the single bench judgment, yes.
No,
For the
my,
single bench for your case. Huh?
my lord, kindly see next year 1, my lord, that is the appointment letter.
Appointment, show us the advertisement. The only issue on which the division bench has gone ahead is that there was an advertisement, whether proper or not, let it be at a later point of time. But as of today, there was an advertisement, you participated.
My lord.
There was an appointment letter. Now you will not question it. What about here?
Then, my lord, kindly take this matter in the next week, my lord.
Huh?
Next week, my lord. Kindly take this matter.
You find out whether your case is covered by the single bench or the division bench.
Yes. On the question of the appointment, advertisement.
Advertisement. If you don't have an advertisement, everything goes. If you have an advertisement, bring it on record now. Huh?
No statement is there. They say that there was vacancy available. We applied and we are.
That will be a dangerous position, sir.
Now they cannot change that. There are two of the institutions.
No, once they say there was vacancy and we applied, one sentence missing. Typographical error. 12th of March. We'll take it up for disposal.
My lord.
Mr. V. Kumar, Leonard Counsel appearing for the petitioner, also Mr. B. Gogoi, Leonard Additional Advocate General and Standing Counsel Health. Full stop, Leonard. The counsel for the petitioner has placed reliance on the judgment of this court passed in WA number 428 of 2023, Narayan Prasad Sarma versus State of Assam, to say that the issue would be covered. The Leonard Additional Advocate General has disputed the same. List this matter again on 12th of March 2026. The matter will be taken up for disposal. My lord. Deeply lodged.
May I please, Your Lordship? My lord, in this case, affidavit has not been filed by the state respondent and the private respondent is there, my lord. The matter pertains to provincialization services, my lord. Petitioner claiming.
Why it was not provincialized?
My lord, the petitioner is my lord senior to the private respondent.
Who is appearing for the private respondent? Don't want to file a reply, sir.
File it, please.
Matter is of 2023. Leonard Counsel Mr. B.K. Das appearing for the petitioner has submitted that the petitioner has been denied provincialization even though he was senior to the private respondent. Respondents have not filed their affidavit. Full stop. List this matter again on 12th of March 2026. Affidavits may be filed on or before 5th of March 2026 by all the contesting respondents, on behalf of all the contesting respondents, full stop. No affidavit in opposition shall be accepted by the registry after the 5th of March 2026, except on payment of cost of ₹5,000 to be paid to the District Legal Aid Services Authority. Full stop. Petitioner would get liberty to file their response to the addition to the affidavit in opposition if any are filed on or before the next date of listing. List again on the 12th of March. Attempt will be made to dispose of the repetition. My lord.
Obliged.
Ask order make and limit. Otherwise, personal.
Let us see whether appropriate.
All the correct.
there was an earlier instruction of an earlier date, which was produced on the Is it not a repetition of what we had recorded in the earlier order?
Basically, not.
The same thing.
No, they're beating around the bush.
Huh?
Beating around the bush.
No, it is saying that there is a litigation pending. And we have asked the judicial department exactly what we had recorded in the earlier order.
But they have nothing more to say. This is what are some person? Typically, the finance department would be required because after a recommendation and being appointed, and the salary, this thing, was it the, when there is a question in regard to salary officer, I think the finance department would be the, this clear party. The competent party to.
Well, the finance department, on the earlier occasion, they have filed affidavit, page 78.
Acha, any earlier litigation in this matter?
Earlier litigation was there.
What is the order, sir?
The order, it was withdrawn because finance department's view has to be challenged. So
Now,
finance
what was
department-
required to be done?
No, because the finance department has said, my lord, the previous prior approval was not given, so will not pay.
That's why I will not pay.
That is what it says. Finance
Is-
department itself is a party while at the time of selection.
Who are they party here?
Yes, yes, they filed affidavit.
Finance department to
was separating it up.
we'll ask him. Finance department to scroll the option. We'll have it after some time. Mr. Das, we'll have it after some time.
Yes. Sir. My learned friend said it correctly, madam, that dishing around the bush. We'll inform Mr. Gozon.
The moment he comes to the item 29. Yes, sir.
May please, your lordship. Now, not here, my lord, the petitioner who was working as Asha, my lord. He has been removed, my lord, without following any norms, my lord.
Where is the removal order?
Removal order, my lord, they have page, my lord, 15 in the affidavit. Page 15, my lord. Page 21, my lord, I'm sorry.
Where is that order of the Joint Director Health
Joint
Services?
Director's order, my lord, page 43. In additional affidavit filed by the respondent. Now, lordship, kindly see page 44. This is their guideline, my lord.
What is VHND?
Please head to nutrition D.
Okay.
Now, last paragraph, my lord, as per Asha assessment report. Received from so-and-so, dated so-and-so, Asha should be considered as non-functional based on indicator metrics mentioned above. In this regard, you can take any action against the non-functional ASHA, such as reorientation, warning for performance, hand-holding.
What is hand-holding? What is hand-holding?
Hand-holding, special evaluation.
Hand-holding, what do they do? They ask them, you are not performing well, let us hold hands. No.
For
Hand-holding.
improvement of capacity.
Huh?
For improvement of capacity, etc.
Mm.
If after repeated effort,
Ah.
one who do not show any sign of improvement,
Mm.
then replacement, my lord,
Mm.
by procedure should be initiated to proper channel. Here, my lord, no notice, no, my lord, warning. On the basis of public complaint, directly, my lord, remove.
Mm. Yes, could you do that, madam? Appointment letter of the private respondent, is there any appointment? Who appears for the private respondent? What do you have to say? Where? Where do you find that?
Another R 219.
Hmm.
And the petitioner's ID number is separate 1231777.
Where do we find the advertisement? Where do we find the appointment letter?
Okay, Lordship may kindly set up paragraph 5 of my affidavit in opposition, my lord.
At page?
Page 17. That as regards to the statements made in mentioned, Dr. Pram begs to state that according to the guideline of ASHA worker, the area of which an ASHA worker is allotted, that area must not remain unattended. Therefore, for non-attendance of this petitioner, she was removed and the respondent number 5 was engaged as the new ASHA worker for that locality with due process, and subsequently the ID number of the petitioner, that is so was deactivated from the official portal. The annexure 2 and 3, my lord. The general meeting.
ASHA workers are appointed by general meeting.
Yeah, now, yes, my lord.
And the removal is by the department. Right. Appointment is by the.
Yeah, the guidelines.
Who
editorial-
appoints?
By the director, my lord. Appointing authority is the director.
Please show us the appointment letter of the respondent number 5.
Yes.
Are we correct in understanding? Are we correctly understanding that the ASHA worker has to go through a selection process? And then an engagement letter is given by the Director of Health Services that now you are the new ASHA you are the new hope, the new ASHA for this area. If that is so, respondent number 5 has not given us the appointment letter. You are saying done in a general body meeting.
That is in guideline, my lord.
What is the guideline?
Guideline in annexure 2 of
Page?
additional affidavit filed by me, my lord, page number 45.
Page number 45.
Yes, my lord. The last second paragraph only, from the last. Grounds
That
of
para will be relevant. Who will select, my lord?
Town Sabha will select one of the 3 shortlisted names as ASA.
Hmm.
The name of the selected ASA along with the copy of the minutes of the approval process should be officially submitted over the SDM and HO. It cannot be arrived at the personal interview will be taken of the 3 shortlisted candidates, and one will be selected as ASA based on the overall performance to be calculated based on her qualifications, evidence-based community centric performance.
What
and
happened after
overall-
this Gram Sabha took the decision? Then what happened?
Before Gram Sabha, my lord, there is a selection by ASHA supervisor. He will send 3 names. Then
Okay.
it will place before the Gaur Sabha. Gaur Sabha again,
Gaon Sabha has already given this.
no, before my lord, without my lord, any list from supervisor. There's so more to my lord.
Your Lordship, may
There is no such reference in the minutes. That 3 persons.
We are only trying to find out regarding his appointment, because if we decide that his disengagement was wrong.
that engagement letter did not issue and does not, in this case, they did not issue the engagement letter. Actually, they give an ID, my lord.
No. ID is given by whom?
And Lordship, may kindly see the Annex 3, the 46, my page, my lord. Page number 46, Annex 3. That ID of the petitioner was deactivated, my lord. With due respect and humble submission, I would like to inform you that 2 numbers of ASA are replaced with new ASA, and 1 number of ASA is to be replaced due to non-functional under Mukalmua BPHC. The details are enclosed here. They are given an ID, my lord. No formal,
This was sent from the SDMHO to the joint director. What did the joint director do?
petitioners.
Huh? Now what happens if we find the termination to be wrong? To terminate her. To terminate her.
Yes, ma'am.
To terminate her. But your guidelines do not say so. This 6/1/2020, it says that you have to give her some opportunity. After the opportunity, you will have to declare her non-functional and then give her an opportunity. If she does not improve, then you go for replacement. And declaring her non-functional and taking away her job on the day 1, is it correct?
ASA, my lord. It also not take the decision.
Could be. Could be. We are not on good. You are not answering the question we are putting to you, madam. We will not put the question too many times. We are running short of time. Kindly tell us. Your memorandum says, if this happen, declare non-function. Then hold her hands. Explain to her. That is what the office memorandum says. I can't agree. Now, once she does not understand after holding of hands, you leave the hands, replace her. You never held her hands. Now what to do? As per ASA assessment report, an ASA should be considered as non-functional.
Yes.
In this regard, you can take any action against non-functional ASA, such as reorientation, warning, hand-holding, special evaluation, etc. Was there any reorientation done? Nothing. Gram Sabha says, please replace her. You happily replace her.
I have to take some instruction on any notice was issued to her.
We'll help you in that. Kindly come to page 43.
43.
She should be considered as non-functional ASA. Therefore, you are directed to replace the ASA. So non-functional and replacement together has come by 18/6/2021. Huh?
Regarding my lord, any warning given to her, I take instruction, my lord.
The letter itself speaks. Declare her non-functional and therefore finish her. What could have happened between paragraph number 3 and paragraph number 2 and paragraph number 3? There is no time in between paragraph 2 and paragraph 3.
And on the same day.
It is on the same date, same letter. How can you insert something there now?
Next, I will take instruction, my lord, in this.
Monday. 2nd of March. Mr. Al Islam, Learned Counsel for the petitioner has submitted that by the order dated 18/6/2021, the petitioner was required to be considered as a non-functional ASHA, and by the same order itself, directions were issued to replace the petitioner at the level of the SDM and HO Mukalmua BPHC. Stop. Accordingly, the order dated
18/6 on the same.
Huh?
On the same thing.
Where is that letter?
Page 21.
Accordingly, by the letter dated 18/6/2021 issued by the SDM and HO Mukalma PHC, the petitioner was requested not to do any activity as ASHA from the same day itself. The Learned Counsel for the petitioner has drawn attention of this court to the order dated 6/1/2020, by which it was required that on declaration of an ASHA as non-functional based on the indicator matrix, actions such as reorientation, warning for perform, handholding, special evaluation for improvement of capacity, etc. were required to be carried out. And in case after repeated efforts, no sign of improvement was shown, then replacement could be resorted to. It is the specific case of the petitioner that due to her absence for a particular period of 6 months, for reasons which are disclosed in the writ petition itself, the petitioner had remained absent. However, she was never given the opportunity to show signs of improvement, and therefore her replacement is not tenable in law. Ms. So-and-so, Learned Counsel appearing for the respondent department, has sought for some accommodation, which is afforded till the 2nd of March 2023, to verify as to whether any corrective measures were taken with regard to the petitioner before deciding to replace her. Stop. The matter has been heard at length, and no further time would be granted to the respondent authorities. They may produce such documents which should reflect the opportunity was given to the petitioner on the next date fixed, list again on the 2nd of March 2026. Mr. So-and-so appears for the respondent number 5.
Right. The matter was, I have inquired regarding finance. I have been informed that the matter was been taken care of by Mr. Cholia, standing up finance. But he has some personal difficulty today regarding his baby child lordship. So requested to me to kindly take up the matter on Friday lordship.
To be taken up on Friday, well, the matter has to be decided finally.
Yes.
It's a case, my lord, where they have denied the approval on the ground that prior approval was not.
So therefore we had by the instructions
So
required from you,
it's-
we wanted to know whether an ex post facto approval has been sought for, in view of the litigations either pending or that had already taken place, and the affidavit and oppositions which were already filed. The department was not averse to giving the petitioner the job. The only requirement was approval.
Approval, yes.
Now, once that approval does not come and
Yes,
the department does not find any other fault in the
appointment
appointment process,
So,
have you processed the post facto file?
My lord, there are a lot of people.
Pending litigation is one thing. We have not tied anyone's hands.
They processed, I have been told, they processed earlier, but it was rejected on the ground that approval. Final decision is.
That is what we want to know.
Final decision.
Ex post, Mr. Borpujari, we are adjourning this matter to a convenient date for Mr. Cholia, no doubt.
Friday.
But what has happened is, an appointment was given, salary is not being paid, letters being written, finance rejects the proposal saying that prior approval was not taken. Department does not find any other fault in the entire scenario. Man has been working. No defect in his otherwise in his appointment series. This court wanted to know that there is a proposal for ex post facto approval from the finance. This has already been done. Court cases have gone. This has happened. This was the affidavit. This. Give us the approval because he is the right man to work. Finance rejects it, saying there was no prior approval, so rejected. Can it be done like that? The request for an ex post facto approval has to be rejected that no, we cannot grant this because this don't fit, things don't fit in.
Yes, yes.
It was rejected.
You did not ask us earlier, so go home now. Delay and laches, would the department be working on that?
Ex post facto, it was asked for.
Huh?
Ex post facto.
Was asked but rejected because there was no prior approval. That is what you said. They're asking for a post facto approval, not a prior approval.
That is true, correct, madam.
And the Secretary of Finance was also a party, man. In the state level.
Finance is a party, therefore, no, we will not say.
The case which I have decided.
Therefore, Mr. Barpujari is here.
Is that madam, I have chosen not to appear in this matter.
Oh.
No, madam,
We will not.
possible kindly appear because I also appear for the revenue department. There is a tussle between revenue and finance. So therefore,
Revenue
will not be
says yes, give it.
prudent, not do that.
Revenue is in favor.
Oh, he knows the matter. Good enough. We'll have it
He
on
said
when?
that on Friday.
On,
It is my right of audience. My
It has been
my
decided
senior
finally by
colleague
the
may
court.
not interfere. It is my right of audience. He may not interfere.
We'll have it on the 18th.
18th.
Looking at the board, we are keeping it on 18th.
Wednesday,
I will.
Release this
communicate
matter
to
again on the
Mr. Chaliha.
18th of February 2026, enabling Mr. Choliha, Learned Standing Council Finance to appear in the matter. Mr. Choliha is requested to be prepared with the instructions as to how
They filed affidavit.
a proposal for the ex post facto approval was rejected because prior approval was not taken. That is only what is hurting.
Yes.
You may have other reasons. The finance may have other reasons.
Well, attempt for disposal.
So the attempt is always there with the proper persons here.
But the reasons have to be explicitly placed before your lordship. That is the only thing left. I will convey, madam.
Haste makes waste, and he who hesitates is lost. We have to stand in between. We cannot hesitate and we cannot be in haste.
Process server not getting salaries 2017.
But then
And
good days
all-
will come if there are arrears. Very good days will come.
I don't know.
I'm so obliged.
On that date, if it is down below, I may be permitted to upgrade it.
Have a mention made in the morning, we'll keep it in mind. But Mr. Swan, council appearing for the petitioner also heard in South America and council appearing for the CDI. This bail petition has arisen out of the arrest of the petitioner in connection with, who is that police? In connection with the FIR lodged by FIR lodged on 24/8/2023 by FIR lodged on 24/8/2023. What is that? Before the Deputy Inspector General and Head of Branch CBI SCB Kolkata regarding an incidence of unlawful assembly, rioting armed with deadly weapon, criminal trespass, mischief causing damage and loss, extortion, theft in dwelling house, possession of firearm or ammunition in contravention of Section 3 of the Arms Act, mischief causing damage to public property and mischief causing damage to public property by fire or explosive substance. On an investigation having been taken up several investigation having been taken up, certain accused had been arrested and a charge sheet had been filed. Madam, you'll have to assist us to some extent. Is it page 39, the charge sheet? No files. Okay. Uh, having been taken up, a charge sheet was filed. Charge sheet oblique final report was filed in the court of the Chief Judicial Magistrate, Kamrup Metro, Gauhati on 29/2/2024, being charge sheet number 02 of 2024 in connection with the aforesaid FIR. Full stop. After the charge sheet had been filed, comma, the investigation was continued. Was it with permission? Was it with leave? That part is not. That part. Investigation was continued and on, what was the date? When were you arrested, sir?
I was arrested on 8/6/2025.
The petitioner was arrested on 8/6/2025. 2025. The petitioner was, it is the case of the CBI that the petitioner was arrested at the airport.
Yeah,
At the so-and-so airport, huh? At the so-and-so airport in the morning hours of 8th of
8/6/2009.
on 8/6/2025, and he was produced before the remand magistrate at Gauhati.
Yes, without
At Gauhati.
at Gauhati.
On, we are not going into any grounds,
Yes.
it's just the facts.
Yes.
Produced before the learned remand magistrate at Gauhati at 4:30 PM on 8/6/2025 itself. The learned remand magistrate had remanded the petitioner to custody, and the petitioner has been in custody ever since. Full stop. Mr. So-and-so learned counsel appearing for the petitioner has submitted that it is not a fact, although recorded thus by the arresting authority, comma, that the petitioner was arrested on 8/6/2025. The learned counsel for the petitioner has submitted before this court that the petitioner had been arrested on 7/6/2025 when afternoon, evening, morning, when evening, and had been in the custody of the arresting authority since that date. The learned counsel for the petitioner has submitted that after the arrest of the petitioner, there were disturbances in the locality of his arrest, and due to such reason, the government had by a particular notification shut down the mobile internet services in the area. Full stop. The petitioner was thereafter taken to the airport on the morning of 8/6/2025, from where he was brought to Gauhati and produced before the learned magistrate. The learned counsel for the applicant has, for the petitioner has submitted that since the internet services were not functional in the place of arrest, comma, which is borne by the records of the government notification, comma, it cannot be the case of the arresting authority that appropriate written communication had been given to the friend oblique, family oblique friend oblique, family oblique relative oblique friend of the petitioner by any means, comma, when it is also an admitted position that due to disturbances, movement of persons within the area of arrest was itself restricted to a great extent. Full stop. The learned counsel for the petitioner has submitted that it is an admitted fact that no written communication was physically handed over to any family, relative, or friend of the accused, and the only stand taken by the arresting authority was that a friend of the petitioner had been called up on his mobile on a number supplied by the petitioner, and The wife of the petitioner was also with the friend of the petitioner, and therefore the wife of the petitioner had enough information regarding the reasons and grounds of arrest of the petitioner. Full stop. The learned counsel for the petitioner has further submitted that the WhatsApp number on which the arresting authority alleges that the grounds of arrest had been sent is not the WhatsApp number of the wife of the petitioner and is rather used by his daughter, is rather in the name of his daughter, a number which he never gave to the arresting authority. It is the case of the prosecution of the arresting authority that the number was given by the wife of the petitioner when they had a telephonic discussion, and therefore the ground of arrest as prepared had been forwarded to that particular WhatsApp number. The learned counsel for the petitioner has further submitted that in the absence of the grounds of arrest being made known to the family, friend, or a family relative or friend of the petitioner, the arrest of the petitioner would be vitiated as has been laid down by different judgments of the apex court. Full stop. The learned counsel for the petitioner has submitted that the story of the arresting authority that the messages were sent through WhatsApp cannot be relied upon in any manner, since it is a fact notified by the government that the internet services had been shut down from the evening from 11:45 p.m. on 7/6/2025 for the next 5 days. Full stop. The learned counsel for the petitioner has further submitted. Yes, any other submissions?
That no transit demand was.
That there was no transit demand, no transit remand.
Was obtained from the local.
No transit remand acquired by the arresting authority to have the petitioner shifted from Manipur to Assam, and therefore therefore when the petitioner was not produced before the immediate remand magistrate without there being any further causes shown, the arrest of the petitioner gets vitiated. Yes, any other ground?
That has been decided by Honorable Supreme Court, Article 22 before the nearest magistrate.
That we will take care of. Anything
that is the main two grounds.
One ground is that the WhatsApp was internet was not working. WhatsApp messages could not have reached on time. It was not on the numbers provided by you. The second ground is that you were not produced before the nearest remand magistrate. Any other ground is what I'm asking.
These are main two grounds.
These are the main two grounds. Ms. So-and-so learned counsel for the CBI has submitted that although by the notification issued on 7/6/2025, the government had declared that the internet services would be shut down. A closer perusal would reveal that only the mobile internet services had been shut down and other LAN and Wi-Fi services were allowed to function.
These line and
Wi-Fi services were.
He is also accused admitted that my Wi-Fi is functioning.
Just that they were functional. Therefore, the assumption that the ground of arrest could not have been sent by WhatsApp is erroneous. The learned counsel for the CBI has submitted that it was an admission on the part of the petitioner himself before the arresting authority that the Wi-Fi in his residence is functioning, and therefore anything sent to the number given by him to his wife would be received by his wife, and that would be sufficient. Service of notice as required in law regarding the grounds of arrest of the petitioner. The learned counsel for the CBI has further submitted that it is not a fact that the petitioner had been arrested on 7/6/2025. Rather, he was arrested on 8/6/2025 inside the airport premises on specific information received by the arresting authority. Since the situation at that point of time at the place of arrest was not conducive for him to be produced before the nearest remand magistrate, the arresting authority had to take the decision to hold him inside the airport, which was a public place, till the time arrangements could be made to have the petitioner brought out of the place of discomfort and produce him before the next remand magistrate at Gauhati which was the next nearest magistrate,
And
remand
that is still
magistrate.
24 hours.
Full stop. She has submitted that the arrested person had been produced before the, since the arrest was on 8/6/2025, and it is an admitted position that the accused was produced before the learned magistrate at Gauhati within 24 hours. That is at 4:30 PM on 8/6/2025 itself. It cannot be said that the petitioner had suffered any prejudice of defending himself at the time of his production for remand.
And to that effect, order is also there. That
The
the
learned
ground
counsel
has
for
been
the
given to him.
The learned
Magistrate
coun-
order is there.
The learned counsel for the CBI has submitted that the orders passed by the learned remand magistrate at the time of production would itself reflect that the petitioner had understood the grounds of arrest, and that he had made his own arrangement for an advocate or a counsel to represent him before the learned remand magistrate. Full stop. Controverting the above, the learned counsel for the petitioner has submitted that even if it is assumed that the petitioner had arranged for a counsel to appear for him before the learned remand magistrate, the petitioner did not have the requisite documents with him with regard to the grounds of arrest. No, you go it like this. Even if it is assumed so and so, was here arranged for a counsel to appear for him before the remand magistrate, the petitioner was highly prejudiced during his defense at the stage of remand, since the family, friends, or relatives of the petitioner did not have knowledge about the grounds of arrest, and the petitioner himself, being in custody, could not give the entire grounds of arrest to the counsel. The learned counsel for the petitioner, you have any other grounds? We are taking the controversy to there so that we remember, otherwise we'll
The
forget.
situation is that he cannot be produced there
said
because of the law and order
We said
situation.
that.
And our submission is that still the situation is not prevailing good, and if he will be released on bail, the situation is further aggravated.
The learned counsel for the petitioner has submitted that keeping in view.
And he was only after thorough search he has been arrested. Otherwise, he was absconder.
No, my lord, nowhere he has been said as absconder.
Sir, we are only now trying to record
Yes,
what
yes.
the arguments already taken
Yes.
place. If we allow an argument now, you will have to wait for another 2 days.
No, my only humble submission, he was never declared.
We are not considering any fresh arguments made today. Whatever has been argued, Madam has said that she had argued it. So we are recording it. The learned counsel for the CBI has submitted that the situation at the relevant point of time at the time during the arrest was not one where the petitioner could be taken out of the airport premises to be produced before the remand magistrate, and even as of today the situation remains the same. Full stop. What was the other one? I forgot. The situation remains the same, and it was only after a thorough investigation that a decision to arrest the petitioner had been taken by the arresting authority to aid the further investigation, and she has submitted that in the prevalent situation, if the petitioner is allowed to be, is granted the privilege of bail for any reason whatsoever, the petitioner may abscond,
or the situation may aggravate.
or that the situation prevalent in the in Manipur for which he had been arrested may again aggravate.
The main person in the
Since the petitioner is one of the main accused
main accused.
who had
And he is the
committed
commander of
acts,
some group. Commander of some group, Tangle.
and one of the main accused person, being the alleged commander of one of the main groups who rioted, who caused riot in
ethnic
the
violence has been
battalion. In the
Ethnic
battalion
violence is also
and
occurred
ethnic violence.
because of the hate speech. And
She has further submitted that the petitioner is also involved in hate speeches. The learned counsel for the petitioner has submitted that once an arrest is found to be vitiated in law, and it is found that the same was in violation of the protection guaranteed to the citizens of India under Article 22(1) of the Constitution of India, comma, there would be no other option but to hold such arrest to be in violation of law, and the arrested person deserves to be set at liberty forthwith. We have produced we have heard the learned counsel for the petitioners, and we have produced the different records placed before this court, comma, either on requisition or on requests by the learned counsel for the CBI and the learned counsel for the petitioner. We are taking everything on whatever has been produced by you and whatever is. Although at the initial stage it would appear that much deliberations would be required to decide as to whether the arrest of the petitioner was in violation of the law laid down by the apex court and in violation of the constitutional rights granted to the citizens of India under Article 22(1), comma. On going through the records, this court finds certain undisputed facts which would aid in adjudication of the matter, full stop. It is not in dispute by any of the parties that, number one, the internet services in the area of in the locality of arrest of the petitioner had been shut down by the government by notification issued on 7/6/2025 with effect from 11:45 PM onwards. It is not in dispute that in spite of the aforesaid notification, lease lines and Wi-Fi's were functioning in certain areas within the localities. It is not in dispute that the petitioner has been shown arrested on 8/6/2025 at the airport premises by the arrest owner, which fact is reflected in the arrest memo, full stop. The petitioner has raised a dispute to the extent that he was arrested on 7/6/2025 and the factum of his arrest has been recorded on 8/6/2025 in the arresting memo. However, it remains a fact that the arrest memo shows the arrest of the petitioner at 9:40 AM in the arrest memo itself. It is not in dispute that the petitioner was not produced before the remand magistrate at Manipur, before the nearest remand magistrate at Manipur. And further, the arrest memo has not been signed by any responsible person who would have been available within the airport premises. Full stop. This court also notices that in view of the situation claimed to be prevailing in the locality on the arrest of the petitioner, comma, the airport would be one of the most secured places where senior and responsible officials would have been present, allowing the arresting authority to have approached any such person to attest the arrest of the petitioner within the airport premises. Full stop. 4. It is not in dispute that the phone number on which the arresting authority claims to have made attempts to inform about the arrest belongs to a family member of the petitioner, comma, either the daughter or the wife, since the arresting authority contends that although the phone might have been being used by the daughter, the number remains in the name of the wife. Or is it ulta?
It is in the name of the mother. Somehow, and she has picked up
She
the.
was,
The daughter.
although it might have been being used by the daughter, but the number had been issued in the name of the wife of the.
It is not used by, she has picked up the call, but because it is not on her name. She is minor, if she is minor, SIM cannot be issued in her name, in any case.
What we are saying is that the number is issued in the name of the mother, but at that time it was in the use of the daughter. Might have been in the use of the daughter is what we're saying. Today, our minors are more well versed in mobiles than even.
But the law does not.
When I cannot understand something, it is my minor daughter who comes and says, no.
That is, yes, they are more expert.
It is not in dispute that though the arresting authority may have made attempts to forward the grounds of arrest to a particular number, comma, the grounds of arrest sent by WhatsApp on that number was received by that number only at 4:17 p.m. on 8/6/2025, full stop. It is not in dispute that the petitioner had been produced before the learned remand magistrate at 4:30 p.m. on 8/6/2025. In the absence of appropriate evidence appropriate material being placed before this court regarding the actual date and time of arrest of the petitioner, comma, whether it was on the 8th of June 2025 at 9:40 a.m. in the airport, or was on a day prior, that is on 7th evening, comma, this court does not venture to base the decision on such disputed facts, full stop. However, this court notices that indeed the grounds of arrest of the petitioner had not been made known to his family, friend, relatives in a manner acceptable in law, and even if it is assumed that the said grounds of arrest had been sent by WhatsApp to the relevant to the number as shown by the arresting authority, comma, the same was received by at that particular phone number only about 13 minutes prior to the petitioner being produced before the learned magistrate at Gauhati, full stop. This court also notices that the arresting authority has did not take the signatures, or this did not get the arrest of the petitioner attested by any responsible or authoritative person at the place of arrest, and there is no assertion that none was available at the place of arrest to have given such attestation, full stop. A submission has, however, been made that given the prevalent situation at the place of arrest, none had agreed to attest the memo of arrest. In view of our finding that the friend, family, or relatives of the petitioner had been informed about the grounds of arrest only 13 minutes prior to the production before the magistrate, comma, this court is of the opinion that the petitioner and or his friend, family, and relatives did not have the opportunity to effectuate a proper defense during the time of his production for remand. The arresting authority has not placed before this court sufficient materials to dispel doubts regarding the arrest of the petitioner on 7/6/2025. Full stop. The grounds given by the arresting authority for not producing the petitioner before the nearest remand magistrate at the place of arrest do not and are not convincing enough. Full stop. In the above view of the matter, this court is of the opinion that the constitutional rights of the petitioner under Article 22(1) of the Constitution of India stood violated, thereby vitiating the continued custody of the petitioner after his production before the remand magistrate. It may be true that the remand magistrate has recorded that the petitioner had arranged for his own counsel, but we do not find anywhere in the order recorded by the magistrate that the petitioner was also satisfied with all the opportunities granted to him for defending the for opposing the prayer of remand made by the arresting. This court cannot lose sight of the fact that the allegations leveled against the petitioner and the incidents which have been reflected in the FIR, of which an investigation has led to the belief that the petitioner may be one of the prime accused in alleged offenses against the society as a whole, a full stop. The petitioner has also proclaimed himself to be a resident of a locality which is beyond the jurisdiction of the learned trial court, which would be competent to try the to take up a trial in case the petitioner is put up for trial. The learned, as per the records, a charge sheet had already been submitted before the learned trial court. Where does his name appear anywhere? In the second charge sheet or in the first charge sheet? Yeah, and the petitioner herein has been arraigned as a accused in the supplementary charge sheet filed in the matter. Therefore, even if the arrest of the petitioner is found to be vitiated due to the reasons stated herein above, this court has to balance this court has to strike a balance to ensure that the petitioner is present to face the trial and its consequences, full stop. In the above situation, this court deems it fit to grant the privilege of bail to the petitioner on the following conditions. We'll jot down the conditions, whatever we have to. What we presently have in mind is 3 sureties, 1 lakh each, at least one of them to be a central or a state government servant, at least one of them has to have immovable property in the state of Assam within the jurisdiction of the learned trial court, appearance on every date without any excuse, not to leave the jurisdiction of the trial court without prior leave from the court. These are the basic things that we have now, and since it is at the stage, a passport if any to be submitted,
Aadhaar card, PAN card.
whatever his identification, he will be properly identified. And we'll also leave it open to the learned trial court to impose such conditions as it may deem fit to ensure his attendance in this thing. And there will also be another condition where you would not use social media to make speeches or videos to be circulated. You may receive messages, private messages, you may send private messages, but there will be no social media for the person concerned. And he will have to himself ensure that his videos don't get circulated, videos recorded after his arrest. Pre-videos, we cannot help it. It may be with anybody and everybody, but it will be upon you to ensure that you do not make any recordings and have them circulated. The entire intention of this court is their fear that provocation might be there, absconding might be there. Those have to be addressed. Otherwise, arrest being vitiated. There's no other way, man. Because 13 minutes is not time enough.
But he has been informed timely because he has given the phone
One-
number.
one-
Communication is there.
In a lighter vein, one secret agent going to the house and dropping down that ground of arrest would have done it.
It was not possible. They are throwing grenades.
Huh?
They are throwing grenades. People are dying there.
It was-
Lordship, this has cognizance has been taken by UNA also, human rights also.
Yes, yes, yes.
Looking to the condition of.
Yes, but then
It's the monstrous act what they are.
to our understanding, when something is laid down,
Yes, that is there, but procedure has been.
the
followed.
vitiation being there,
Exceptions also, looking to the scenario.
definitely.
There should be a certain exceptions also. The situation does not allow, all are under fear. Even the judges and prosecutor are under fear. That is why this case is transferred here. This is one of the.
On the last occasion when we had this discussion, we had also perhaps remarked that even a jail at times is not enough to contain a person. So that would not be reason for us not to say what is wrong and what is right, according to us. We may be wrong, but then we can say what is right and what is wrong. Yes.
Much of
I think 35 and 36 and 37.
Ah.
My friend Mr. Sharma, he has an
Uh,
appointment with the doctor.
Oh, yes, yes. Was it not mentioned in the morning? We could have asked for an upgradation.
This case, he was in urgency, he has urgency.
Huh.
The problem is that I have not filed affidavit.
Huh.
Client is after him.
No, if you are not filing a affidavit, sir, can we go by the doctrine of non-traverse and allow him the relief today?
Lordship.
That will be too dangerous.
By the last occasion, my lord.
Actually, I was.
Got given the last opportunity.
I was not there.
My friend was ill, my lord. That is why, my lord, I was not pressing.
Using our discretion, we can give him a further last opportunity.
My friend.
But you have to ensure that the
affidavit.
Because we'll be following the routine that we have been following. We'll give you a particular date to your choice. Any affidavit filed after that will entail costs.
Okay, then Lordship.
Choose the date.
Lordship, I will file by fix it on March 11. Lordship, I will file. I will do the argument, sorry, hearing plus.
No, he'll require some time to reply to whatever you give on affidavit.
During that period.
Mr. Pisham,
then in that case, March 5, 6, and that time we will.
No, we'll fix this matter for hearing on. You can file it by 6th.
Yes, I can file by 6th.
Or we'll keep it on we'll allow you to file it by the 6th. List the matter on 17th. That is a Tuesday. A hearing day. And Mr. Saika, you file a reply before that.
17 March, my lord, is a month, Tuesday.
Tuesday, a hearing day.
My lord.
We'll have some time if you want. Mr. P. Shamal and Counsel, appearing for the Fishery Department, has submitted that the affidavit in opposition would be filed on or before the 11th of March 2026. Full stop. Mr. I. Sekar and Counsel for the petitioner has expressed urgency in the matter and has sought the matter to be fixed at a short date thereafter, by which time he assures that the reply affidavit, if any required, would be filed. Full stop. Accordingly, list this matter again on the 17th of March, on which date it would be taken up for an attempt would be made to dispose the matter. Full stop. Mr. Sharma is put to notice that in case the affidavit in opposition is not filed on or before the 11th of March 2026, this court, the respondents may have to incur costs.
My friend may be directed to produce the record of the DPC also.
Mr. Sharma shall also be supplied, shall also be armed with the records of the matter.
My lords.
Whatever records you want to produce, it should not be a date when after everything you tell us that, okay, I'll get the records. Carry the records.
Right.
Then relates to the pensionary benefits, Lordship, maybe some area dues. Petitioner retired in the year 2020. September 2020, but till date not released his pension.
Why is the pension?
Area salary, nothing has been released, Lordship. District Commissioner already filed his affidavit in opposition in this case also, Lordship. He is saying that the petitioner is drawing salary under the head account of CGM, so that's why he could not initiate any further.
Who?
District Commissioner.
Oh. Mr. Das,
That's why in the last occasion.
how do you bring a resolution to this?
Recently, I have received 2 instructions. I think I should file a certificate clarifying this. Now I can address the problem, what has happened. He was an employee of, he was a peon of government leader in depot. Initially, all are merged, then separated. Then he retired. Now, state deputy commissioners in the affidavit says that he has worked for certain period. Wherein he was not paid salary. So he is entitled for area salary. But what the finance department has done by sanctioning the amount for the area salary, they have sent the amount in a head under the CJN. Wherein she doesn't have the petitioner to be an employee.
So to whose account should it have been, what should have been the head? Should it be to the deputy commissioner?
Yes, it has to be.
Okay, who appears for the finance? No, we'll go step by step. Once the area salary, if it is already sanctioned, if it is done under the proper head, some respite in his retirement. By that time, we can find out who is the authority who should have processed the pension papers.
There is another problem here. Post-petition letter, the DPM, I have received the instruction from judge, she asked the deputy commissioner with regard to post-petition letter.
Missing.
It's not there.
Missing. I'm telling you, it's missing. A little.
We have the instructions one.
We have, but the post creation is not disputed.
No, they are affiliated.
Pension is for the service rendered, not for the post created. That they will create one. They will deem one. Where is the finance? Have you made the finance a party? Now we will say I have to make finance party.
Yes, look, respondent number 3 is the finance.
Dear finance, I will scold you. We'll take it up when the finance is here. Otherwise, discussing it is not helping. We'll waste time. We'll do it once the finance is here.
In this case, my lord, the respondent number 3 has filed the affidavit in opposition, my lord. I have received the same, my lord. My lord, I want to file reply.
So, respondent number 4, here, see the paragraph on it. So, you need to file that.
Case of? Case of? Dismissal from service.
So, respondent number 3, the appellate authority has filed the affidavit. The PA authority, they have given the paragraph, filed that. Let's be final.
Yes. You can allow it to be. Have you seen page 28? Just see page 28. And then you can stand in between the two counters and then make a submission. We can say it's a fair submission. See?
Let me file the affidavit, Your Lordship.
Totally settled law. I understand, but your name is Basudev Burman.
My lord.
Oh. No, the dispute is between bribe and fine. Whether it was bribe or whether it was
Fine.
Fine. Fine if illegal is bribe. How much time, sir?
Your Lordship,
See, a man is out of service,
I understand, Your Lordship.
and the sooner you can hold a fresh DP, the better it is.
Yes, yes. 2 weeks, Your Lordship.
Can we have it on March 7th? See, these are, we are keeping it on that day because the disposal is possible.
Yes, yes.
All matters we are taking up on Saturdays, whatever on the list, we'll try to go for a disposal. Either fixed or listed by the registry.
7 months. Yes.
Marginalized and all. 7th of March, Learned Counsel, Mr. D. Bora, appearing for the state respondents is afforded an opportunity to file his affidavit in opposition. Full stop. List this matter again on the 7th of March 2026. Full stop. This court notices that the second so-called notice, that the issue raised in this petition is maybe one covered by earlier decisions of this court. Mr. Bora would have his instructions on the same. Next. Reply file.
Lordship.
What is the matter about?
Lordship, in this matter, my lord, that in a disciplinary proceeding, my lord, initiated against the delinquent, my lord, and annually implement, my lord, has been withheld by the disciplinary authority, my lord, for the fault of the director, my lord.
Where is that impugned order?
Lordship, kindly see, I have challenged the impugned order, Miss page 65, my lord.
Huh?
Page 65, first part of the impugned order.
What is your name?
My name is Kakeshwar Babu.
Huh?
Kakeshwar Babu. I am the senior assistant, my lord. And decision has been taken by the director, my lord. And due to the fault of the director, I am suffering, my lord.
Why did you hand over the?
As per direction of the director.
So I think
Appointment letter issued by the director.
Executing an unlawful order does not protect you. Simply saying director told me. Tomorrow director will tell you in Hindi they ask na kudne bolega kud jaoge.
Suppose your lordship director clerk, then they handed over to him.
So why should you go and do it when he's one of the person who knows that the letter is a wrong letter?
Lordship, kindly see.
It is a fake letter. It's a fraud. It's a fraud.
Page 59, lordship.
Page
59.
Yeah.
And they have taken the decision, my lord. Inquiry officer as well as the director, my lord. And who is the inquiring the matter for his own?
This director must be the earlier director.
But inquiry officer is the coordinator, the examination coordinator is the inquiry officer.
She's saying that this man failed, yet he was given an appointment of.
She has taken the decision. Lordship, kindly say, assistant curator, IC curator.
Where is the inquiry report?
Two inquiry report. First is one assistant curator has issued a show cause notice, but he has no power. She has no power. Thereafter, the director issued.
So we forget the first one. We go by the director.
Lordship.
What does the director do?
Lordship, inquiry report. Page 41.
41. And why is the disciplinary authority issuing letters calling them to face the interview? Page 39 has been issued by the director, requiring them to be present before the inquiry officer and the presenting officer. Is he presiding over the disciplinary proceeding? This director is presiding over the entire inquiry. Is it allowed?
Director as well as the curator also.
Is it allowed? Should he know when are the witnesses being called, what is happening, what is not happening?
No.
It should have left it to the inquiry officer.
This should not actually should have. This should have been sent by the inquiry.
Ah,
It should have been sent by the inquiry.
just a minute. Show cause reply, show cause to show, appointment of inquiry, statement of borrow, notification, and so on. Who are the persons who have been charged?
Professor Borobala, senior assistant. Petition.
And what is this at page 41? Cross-examination of the delinquent clerical assistant. Eh? Is he supposed to cross-examine or he is supposed to be cross-examined? Kindly tell us. Request for provide me cross-examination statement, recording copy also.
But the same has not been provided to me, my lord.
Who was cross-examined, you or the other persons?
No, my lord, they have not cross-examined me, my lord.
Where is the record? Do you have the record?
No, there is no record, my lord. That is why. They have not, that is why they have not.
This নারিকলৰ মূল্য কি বুজিব?
It seems the accused was cross-examined, your lordship, what to do.
But due to fault of the director, my items have been, my lord.
When
And
can
from
you have the
top to
records?
bottom, my lord,
Learned friend
curator
is
is
actually not
handling
like
the matter.
pressing on the main issue. But
He is more on sympathetic and
Yes.
evidentiary value,
Yes.
which we will reject on the face of it. Come up with some procedural lapses, sir. We cannot keep
Okay.
discussing merits. When can you have the records? I think we'll need the records. Here, just the other side of the pond. Have it requisitioned by the 6th of March. February, we are not putting anything. 6th of March, have the records ready. Once the records are received, we'll take it up on the 10th or maybe 10th, 12th. We'll fix a date and we'll take it up. That is 10th or 12th of.
12, I have said.
We will have it listed on 6th for you to produce the records.
Yes.
We'll hear you on 10th or 12th.
10th, lord.
We'll decide on 6th when to hear. Okay. Mr. D. Bora, Learned Counsel, appearing for the respondent number. For all the respondents is given an opportunity to requisition the records of the disciplinary proceeding held against the petitioner. Full stop. List the matter again on 6th of March, by which date the respondent shall ensure the production of the records. Full stop. Yes.
May I please also?
Oh,
Petitioner is a science graduate and after completing his DLED examination under SCRT method, he also completed the TET examination and appointed as an assistant teacher in AME school in the Karbi Anglong district. After getting few months salary billet, his salary was stopped. And upon inquiry, he was verbally told that his center code in the DLED certificate, there is a discrepancy in the certificate. Therefore, it was.
The salary was stopped.
Yes, sir.
Okay.
No interim order was passed.
Yeah.
It was verbally informed. Your Lordship may kindly see the order of 7/11/2025. Upon instruction, my learned friend was submitted that.
What is the center code?
Lordship will find it page 25 in the certificate.
No, I'm not understanding. You were offered appointment.
My lord.
You got appointment.
My lord.
You were paid your salary.
My lord.
Thereafter, they stopped your salary.
My lord,
They stopped your salary.
Yes.
Then they are now saying that in one of your education certificates, the center code is not matching.
My lord, they are not disputing my passing of the examination, only the center code. It was only
Is
verbally.
salary stopped like that, sir?
From my instruction, yes. Lordship.
He is a fraud. It's a fake certificate.
Not only in this case.
It's a fake certificate. Give him a show cause, take away his job. Give him a show cause, take away his job.
Lordship,
Suspend him.
to show cause, Lordship, there has to be proper evidence and verification. But now the documents are everything.
So you will not give him the salary. So you will not give him the salary.
We have no stop. It's he is on the Caribbean law.
Who is Karbi Anglam?
That Karbi
Yes,
Anglam
madam. How do you stop the
comes in
salary?
They had asked for verification and in the
Yes.
instruction Lordship, we have sent communication, the position.
Tell us. How do you stop the salary? Tell us. Come this way. Huh? By whom? And his salary stopped. We will pass an order, stop the salary of the SCERT. Why should his salary stop? No, his salary will not be stopped. Give us a reason when you can stop salaries. Are you alleging that it is a fraud, case of fraud? It is a case of forgery? It is a case of not passing the examination? No, it is like saying that there is a discrepancy in my employee's driving license and I should not be allowed to serve. Can it be? Someone made a mistake in some of his answer script. Your allegation is not that it is a homemade answer script. Can you stop the salary? You're working.
Yes, madam.
Your attendance is there.
Yes, madam. He is regularly appointed, my lord. The Lordship will find my appointment at page 31.
Page 30?
Page 31.
And there is no order stopping the salary?
No, my lord, nothing. Only verbally informed that there is a.
Have you filed your affidavit in opposition, madam? Huh? You will not file an affidavit. When? Till the time the affidavit is filed, kindly continue to pay him the salary. Once you file the affidavit, we'll see whether it is correct or not. The area part we will see. Salary was stopped from a particular month on a particular decision. And thereafter, from when have you not got your salary?
My lord, to April 2023.
April 2023 till now, no salaries. Hungry man is angry man. He'll be a very angry man. Can you do that? One allegation against him we would have considered.
Your Lordship, may kindly take it up on Friday then, Lordship.
Friday,
My
have your
signature
instructions
date-
by which order the salary has been stopped? By what authority has the salary been stopped? If there was no authority, the person who is supposed to pay? Who is your DDO?
Is the under the Caribbean law.
Who is your DDO? Who is your drawing and disbursing authority?
It will be Inspector of Schools, Caribbean. Respondent number 7.
Huh? Mr. Talukdar, DDO is the IS. Drawing and disbursing authority is there, no? Director Education Karbi Anglong. Have you made him a party?
Director is not a party, my lord. Serving in autonomous service. My lord, I have made party, my lord, Secretary of Department of Education, serving in autonomous. Secretary is the party. That's one of 4 men. Secretary.
The heard Mr. Swain Council paying for the petitioner. Also heard Mr. Mr. B. Chaudhary, Learned Council paying for the SCRT. Mr. B. Chaudhary, B. Talukdar, Learned Council appearing for the respondent number 1, Miss. And madam, you are appearing. Full stop. The salary of the petitioner has been not paid from
April 2023.
April 2023. Writ petition was filed in the year 2024. Notice was issued on 19/12/2024. Standing counsel for the KAC for each of the departments had appeared on that day. There is no return filed in the writ petition. Full stop. Well, a counsel for the petitioner has drawn our attention to the fact that the salary of the petitioner has been stopped without there being a written order to that effect. Full stop. Instructions placed by the director of SCRT reflect that the SCRT is not in a position as of today to trace out the details of the study centers to bring the to bring a quietus to the queries raised by the KAC from the education department, from the SCRT. Full stop. The KAC, it was submitted on behalf of the KAC that there is a discrepancy in the exam code. What code? In the center code.
Center code.
Center code. In the mark sheet comes certificate of the 2-year DLH certificate obtained by the petitioner. Full stop. It has also been submitted on behalf of the KAC that unless the salary of the petitioner can be paid once the rectification of the anomaly is carried out. Full stop. It has not been brought before us that the anomaly had occurred due to some action of the petitioner, or that the petitioner is required to take any steps for carrying out any anomaly when it is not the case of the respondents, that the petitioner is admitted to any such anomaly. Full stop. The respondent authorities are given liberty to file their affidavit in opposition on or before 26th of February 2026. Full stop. The matter be listed again on the 9th of March 2026. If the affidavit in opposition on behalf of the respondent authorities, in case they intend to file one, are not filed on or prior to, what did we say, 23rd? Huh?
26.
No, file before 26th of February, the respondent shall be liable to be imposed costs for non-cooperating in the adjudication of litigation.
May I pray for observation regarding the current salary, at least.
Since no plausible reason has been placed before this court to deny the salary to the petitioner as of today, respondents would be at liberty to release the current salary to the petitioner in case he is found serving, in case he continues to serve.
I would like.
Yes, sir.
If some query is asking something.
And why did the CGM deposit it? Hmm. That money is not his. It cannot be his office's money. So it has to go back to the government. Huh? Now, who are the officers who can sit down and resolve this? It is not a case where you are disputing his entitlement. And every day's delay may again bring in interest and costs, and we do not know someone is not getting paid, no salaries. No, not as of now, but if you find that people are forgetting, huh? At the request of Shri B. Gogoi Learned Additional Advocate General and Standing Counsel Finance Department, list this matter again on. Give us a date, Mr. Gogoi. The area salary has already been sanctioned. For him, perhaps it is Gosot Kothal Uthot Tel. Kothal is not coming down.
My affidavit also
Will not help.
resolve it. That's why I requested.
Huh? Will you have it on 25th? 25th. 27th of February 2026. Full stop. The name of Mr. B. Gogoi shall be reflected in the cost list. Huh? For the respondents. Kindly see if Mr. Gogoi, you can appear in the matter on the next date, because you would have the instructions, you have understood what is going on.
I have also furnished my instruction to him. So, yeah.
That will be good.
I leave.
Yes.
In this case, the petitioner before Lordship was appointed initially on compassionate ground. She was appointed as master roll worker. Thereafter, her service was regularized. But after regularization, she is still being paid the master roll wages due to non-availability of fund. Now, perhaps in the meantime, 2 employees from the municipal board has retired. Now, perhaps the fund is available. They can release the regular salary to the petitioner.
So what do you say? Would you like to release fund because 2 persons have retired? If you appoint someone else, then again no fund. What will you do? No reply filed, no affidavit, no position.
She has admitted our stand.
It is an admitted case.
My lord.
We'll ask you to pay.
My lord.
Then we'll ask you to pay.
My lord.
We'll close this petition. Yes, Mr. Burua. Admitted position. Where is the affidavit?
Affidavit page 25, my lord.
What does it say? Is there a dispute that she should be paid? And then we don't need your affidavit. Then we don't need your affidavit. Heard Mr. I.S. and a counsel appearing for the petitioner. Also heard Miss appearing for respondent number 4. No, not only the respondent number 4, you will also have to appear for the others. 3 and 4. 3 and 4. 3 is the executive officer. The respondent number 3 and 4. Please stop. The petitioner is an employee under the Municipal Board, where he was initially
Page 16, my lord.
where he was appointed as, huh?
Master of the order, my lord. On compassionate term.
Page?
Page 16, my lord.
Page
Lecture 4.
16. Where she was appointed on 28/10/2015 as a master role worker under Sorthebari Town Committee as it stood then under compensatory ground. What is compensatory? She accordingly joined.
Joined on, my lord.
Full stop. She was later promoted as the lower division assistant in the office.
But page 18 is the regular appointment.
The promotion is of when once you're promoted, do you need to go back?
No,
to
no,
that?
not promoted. Appointed as lower division assistant.
Oh, now by the order dated 13/2024, the petitioner was informed of the decision to regularize her services and of her appointment as a lower division assistant in the pay in the scale of rupees 14,000 to 49,000 with gateway of rupees 5,600 plus other allowances applicable with effect from 1/3/2023. Full stop. It is the case of the petitioner that she has not received her appropriate salaries after her posting as the LDA, and therefore she has approached this court praying for directions to the respondents to grant her the appropriate salary, comma, both arrear and current. The respondent number 4 has filed an affidavit wherein the deponent, wherein a stand was taken that it was only due to lack of fund that the writ petitioner could not be paid her regular scale of pay. It is tried law that lack of fund cannot be taken up as a ground not to pay legal dues to regular employees serving in an organization. In view of the above, and it has also been submitted by the council praying for the municipal board that now with 2 or 3 of the employees having superannuated, the funds can be arranged for. In the above circumstances, this petition is disposed of by directing the respondent number 2, 3 and 4 to make necessary arrangements for payment of the salary of the petitioner at the dues to which at the rate to which she is entitled to on and from the month of March 2026. Arrear salaries, if any, prior to this period shall be calculated.
1/3/2023.
Arrear salaries, if any, payable to the petitioner prior to March 2026 shall be calculated and paid to her within a period of 6 months from date of receipt of the copy of the order, a certified copy of the orders of this court. The petition accordingly disposed of, no costs. Yes, sir.
No inquiry, no so cause unceremonious.
And it was after a selection process were appointed.
Yes, and the impugn order is at page 43. First order, your lordship will find at page 42. And from this order, even the honorarium has not been paid to him.
of around 15,000 rupees per month. Mother is sick and ailing. When we filed this petition at that time only, we gave her. That is yes and no.
Supposed to conduct an inquiry by the order date 10/7/2024. 10/7.
Yes. Then your lordship will see that.
Just a minute. This is 10/7. What is 11/7? 15/7 talks of 11/7. 11/7.
Yes.
What is 11/7?
Page 42. Page 42.
No, it is 10/7.
10/7. Then 11.
Something came in between.
Then 43 is the 15/7.
So 15/7 starts with the word in compliance of order dated 11/7. That is what we are asking.
Deputy Commissioner has directed. That order we have not fixed. Yes, sir.
Yes, sir. Tell us this. By number 3 and 4. Yes, sir.
So far that 11/7, your lordship will see the number is the same. Order number is.
Okay.
But it may be a typographical error.
Yeah, 9. Yes, we have seen there was some complaint. Then you wanted him to allow him to work after he said sorry, and then you received 3 more apologies. Now, where these apologies of incidents which occurred prior to his apology or after his apology? It has to be. Huh? Because see, now today, if someone stands up and apologizes that I have got 3 complaints against me, I'm sorry. Then you get another letter complaining of something which was during that period only. Can you hold him guilty then because he apologized? Exactly, that is what we are asking. Where does it say so? Yeah, 13, it does not say that he did not go because he would be assaulted. Oh. Okay, now he appeared before the committee and he said that, okay, I was apprehending assault. Now he was before the committee. Why not give a hearing then? Then that is what we are saying. Now, first you give the inquiry report, no, he has not appeared. Then you get hold of him and say that, okay, now why did he not appear? Nothing on record.
And even that.
After the inquiry.
So, what is the inquiry about? Were the copies given to him? Is there a charge sheet?
No.
Or is it a preliminary inquiry?
Right. But the whole sampling type of inquiry
Should have been there.
Oh, that would only be from the record. So, from time I'll get the record. The record say that.
And your lordship will say, my learned friend has said of three complaints. When we filed the RTI, we found that it is only 1 complaint, and that complaint is the same complainant who had filed the earlier complaint.
Is it of a later date?
Hello?
Is it of a later date? Is that complaint after your apology?
Yeah, your lordship will find. I'm just checking the date. Just 28/5.
10/7, there is nothing wrong.
Later, 28/5. And it is only the one that letter I have given at page 149 of the affidavit in.
After 15/7/2024, what happened?
My lord, I was called to the office. The circle officer is sitting, the Lat Mandal is sitting in the office, saying that you give a
Apology, and you gave the apology.
And
Then what?
don't tell anyone that you have apologized. You keep it a secret. We will reinstate you. Now, all these months, no honorarium of 15,000, nothing. Mother is sick and ailing, and my lord, the daughter is there, and my lord, there is bereavement in the family also, and how can you actually
You, what, his salary, his honorarium. Now, if you have not terminated services, if you have not assigned work, honorarium has to be paid.
That's the law.
But they have stated that the honorarium of the remuneration of the concerned doctor has been kept in abeyance. I mean, since he was also temporarily asked to send the charge of his lot for the property.
Now tell us one thing, 15, let us be very clear, 15/7/2024, you allot his works to someone else. There is an inquiry. He apologizes. There is another complaint. You decide not to allot him work. Done? What happened after that?
Nothing. Your lordship has put a patent, but nothing.
Dismissed him, removed him, withdrew all work from him. What happened after 15/7/2024?
We
This Pallab Kotoki, Pallab Kakoti or Kotoki, whoever is, he is handling two gowns, two lots or two gowns. We need one for each. And the last 1.5 years, one man, two lots, and everybody forgets it. Convenient. What Mr. BD is.
just for a moment, at the fag end of the day, I'll not trouble your lordship. We filed a RTI application seeking for the investigation and inquiry report. They take shelter and each of the right to information and chain that it cannot be provided until the matter is disposed of. That means there was
by the court.
Yes. So that until the matter is disposed of. And when we sought about the 3 complaints, they said that only 1 complaint is there and that they have furnished us the copy.
And what is the complaint? What does the complaint say? That you misbehave with the public?
Means what has happened?
No, but we don't want to know the actual incident. We just want to know the complaint is he misbehaves.
Not me, my wife.
Oh, your wife misbehaves.
My wife lost the election. So someone was ridiculing. So she said some harsh words.
Yes, the allegation is that his wife misbehaved.
And it is, in my, it's
making a mockery of all the authority that is invested in a. It's mockery of the entire system. No, that is an RTI. That your complaint is your wife was angry because she lost the election. Someone mocked her and she misbehaved. We will not give you any work.
And the gentleman who has complained, he is only of 1 shuburi out of 10 shuburi. 9 shuburi has given representation saying that this person.
When a wife misbehaves, seldom can the husband be held guilty of allowing it to happen. It happens. Is it not?
Even the husband can't go and inquire the wife how the fight started. That will be again another backlash for the husband.
That is what I said, that when a wife decides to misbehave, seldom can the husband interfere.
Yes. No,
He is a mute spectator.
I can't ask my wife what has actually happened.
Mr. D. Bora, Learned Counsel, appearing for the 3, 4, and 5, praise for an accommodation to place before this court the relevant instructions as to what had transpired. After the order dated 15/7/2024, and whether any further decision had been taken with regard to the allotment of work to the petitioner herein. The petition, it appears from the pleadings that the petitioner had not been allotted works because of complaints raised against him. Mr. B.D. Kaur, senior counsel appearing for the petitioner, submitted that the complaint related to some agitation expressed by the wife of the petitioner.
That your lordship will
after-
not quote it.
No, it is there in the complaint.
The
Has
complaint by,
submitted that the complaint had nothing to do with the behavior of the petitioner in the discharge of his duties, and therefore there could have been no occasion for the petitioner to be not paid his honorarium or to be allotted duties. Full stop. List this matter again on. When would you have it? 27th of February.
February.
27th of
Bless you.
February. Full stop.
Attempt will be made to dispose of this.
We are making an attempt wherever
Yes,
things
sir.
are available.
Yes, sir.
Without putting that, we are doing it.
We are deeply obliged. Sir.
Oh. What is this?
May I please, your lordship, here in
Yes.
this case, the petitioner father,
Hmm.
while working as a section engineer
Hmm.
under NF Railway, died on 26/3/2025. Thereafter, my lord, the petitioner is a minor. The mother is representing before your lordship by this writ petition for this all retirement benefit as well as family pension, etc.
No, you are saying that so-and-so minor represented by the mother.
Mother,
Mother of whom?
mother of that girl.
Mother is not entitled to.
No, mother is divorcing. Mother.
Okay. Yes, Mr. Gupta.
Mother has no local.
To appear for the minor.
Yes.
Who has signed this affidavit?
Order by.
Oh.
Huh? Yes.
Not guardian, it's custody. It is always misleading, not custody. My lord. Yes. Sir. Because
Or we should put up a note there: when one stands, the other sits.
no, it's all right.
Easier.
Because
Yes, just tell us this thing. Is the daughter entitled to pensionary benefits? Is she entitled? Has it been paid? Has she been paid? You want a minor to go to the court and say that my father had the custody, my mother divorced him, please give me a guardian. Now to sign that affidavit, she would require an adult to be with her. You have not paid her a farthing. How will she take an adult before the notary officer to sign the affidavit and pay for the attestation fees? Tell us. Who is this person who is responsible for giving this? Who is responsible to release, to give a bank draft to the minor? Who is the person?
We are ready to process.
Please bring it on the next date.
Lord, the guardian should come.
No, this court is the guardian.
We have for the,
The
my lord,
court is the
guardianship
guardian.
certificate.
We are
We
saying,
cannot give to anyone, my lord.
we are saying that it is a minor
My lord,
whose father is dead
my lord.
and who has a natural guardian.
yes,
Can you dispute a natural guardian?
there is a law also, my lord.
Who has signed this
The
affidavit?
custody of the child now is with the grandmother.
No.
Show us that
Page
document.
35,
Again misrepresenting, my.
Page 35.
30?
35.
Again
35,
misrepresented.
yes. No,
Page
let us see, let
35.
us see. 35, where is it?
Page 35,
Hmm.
Lord, is the order by the district and session judge. My
But
lord,
that is custody, my lord. Again
let me complete, my lord. Let me-
Ah, yes,
my lord.
please.
My lord, the custody of the child
Hmm.
born out the wedlock in Malakar shall be with Bablu Malakar.
Hmm.
That means, my lord, with the husband.
Hmm.
Now, presently, the custody of the child, my lord, is with the grandmother.
From where do you say that?
And my lord,
From where do you say that? Please justify your statement, Mr.
my lord, this
Gupta.
is, my lord, as
Don't-
per
don't
the
slip away.
instructions which I have received
Ah,
from the
who has
railway,
given you that instruction?
that the custody.
Who has given you the instruction?
My lord.
Who has?
My lord, the department has.
No, the walls have not given it to you.
No, no.
There's a person concerned. A rank,
No.
a post, a man holding a post, the name. Give us the name. Give us the name.
No.
Tell us the name.
But I
No,
have.
telling me, my lord, is not helping. Tell us the name. Who gave you that phone call?
I don't know.
Who gave you that phone call telling you that the custody is with the granddad? Huh? Kindly find out. We'll give you 5 minutes.
No.
That man is before this court
No.
tomorrow morning.
No.
All piece of matter. He cannot support it by documents that the custody is with the custody or guardianship is with the daughter.
2022, the custody was with the father.
Mr. Gupta, just step out of the role of defending a illogical or irrational submission. Don't do it. Listen to us. A minor has a natural guardian. What is custody and what is guardianship? Do you have any doubt on it? 15, 20 years at the bar, there should be no doubt on what is custody and what is guardianship. Who are the guardians of minors by law? Who are recognized as guardians? Mother is what? The first natural guardian over and above the father. Is it not? The father has died. The minor now stands alone. The natural guardian is there. All the benefits are being sought for the minor. The mother has signed the affidavit saying that it is my daughter. She is entitled. She does not have the authority to sign an affidavit or swear the truth of it. I am swearing it. Give whatever is there to my daughter. Correct? It is upon the daughter to do what she wants to do, whatever guardian she wants to have, she does not want to have. She cannot approach the court by signing an affidavit. You are asking for a what? Guardianship certificate. When do you need a guardian? When you don't have a guardian. Is it not? When you don't have a guardian. The mother is the natural guardian. How many more guardians do you need? She is not going to study in a hostel that she will require a local guardian, one foreign guardian, one natural guardian, one legal guardian. Is that the situation? No. Mother, natural guardian. Have the pensionary benefits calculated? No. A bank draft in the name of the minor of all the benefits. A PPO in the name of the minor with all the benefits. On or before when? Give me a date. On that particular date, if the documents are not here, the salary of every person involved in this pension case is going to stop.
Lord will give 2 weeks, my lord, on 2nd of March.
Is there some humanity left somewhere?
No.
Is it not a role model employer? Forget the role modeling part. Where is humanity? A minor girl crying in the court? And your stand? Custody was with the dead man. Send her to the dead man then, along with the custody. Can you?
No,
let her be in his custody.
We are also concerned, my lord.
You are not.
To give.
You are not.
Wife has come after so many years.
Who is the wife? Wife has not come for any place. Sorry.
Mother was not having the custody.
The wife is not. The wife does not. Give us a bank draft in the name of the minor. A bank draft will do.
No.
It protects. Have you asked for a bank account in the name of the minor? Whosoever be the guardian be. Have you approached the court saying that this young kid, we need to pay the pension? She does not have a guardian according to us. Honorable court, please give a guardian to her. Any friend can approach the court?
No.
Have you approached if you are so concerned? No. Has the person advising you approached the court or the child welfare officer saying that this child does not have a guardian, please appoint one, we need to pay? Has he done it? No. And you say he's concerned. Lip service. Is this concerned? And Mr. Gupta, you are defending it.
No, no, I am. My only concern was his wife has did not had.
Now do you have now do you have the concern any
The
further?
mother also comes as a guardian.
Now,
my lord. So we can say to-
now do you have any concern as to whom you are required to pay?
No.
No. You have a bank
Will-
draft?
Yes.
You have the PPO order?
No.
Prepare it, bring it to the court. Ask your mother, the friend of the guardian of the minor,
Yes, ma'am.
to be present in this
Yes,
court,
ma'am.
along with a
Together she's
bank
present.
account, along with a bank account in the name of the minor,
Girl child. Yes.
and an affidavit that none of this money is going to be utilized except for the benefit of the minor.
Child. Yes, ma'am. Mother, today also mother is present, my lord.
We need that affidavit
With the child.
on the
Yes.
next date.
Yes, ma'am.
We need the bank account number.
Yes, ma'am.
Next date, either the pensionary benefits in the form of a bank draft and the provisional area pensions, the final PPO, all, or further down the line, praying for exemption from custody. This is misappropriation. We'll take it away as misappropriation. We may be wrong. Get us corrected. It will take some time.
He's saying the daughter is with, come with her.
When?
Yes,
When
yes,
do we
yes.
have that? When
Still
can you
there,
have that?
still there.
When
So
can you
this
have
month
that? Give
first
us
of-
your choice.
2nd of March, my lord.
2nd of March. Holy gift.
No, it's open on Monday.
Holy gift.
My lord, no.
I'm saying holy gift.
2 weeks.
Huh?
We will require.
See, Mr. Gupta, there are things one can understand, there are things one cannot understand. And there are things one refuses to understand. We refuse to understand.
I just want to know it should go in the
And
correct
none of
marks.
this was pointed at you.
No,
It is at the attitude expressed
no,
by saying we are protecting,
no.
but taking everybody down here. The concern is taking everybody down. One bank draft was enough.
I will do them.
One PP order is enough. Without a bank account, nothing will happen. A minor's bank account, the bank will not allow it to be.
Yes.
Is it not?
Yes.
Take down conditions only for school fees, only for this, only for that. Ask for all of it. It's a mother. Mother is not asking for it.
That is, I will ensure.
Minor, divorced parents, father expires. Mother did not have the custody because she remarried or she did whatever she did. Child stays with the father expires. Good plot for a Hindi movie. And you are joining on it. Your
I will
department.
ensure.
2nd of March.
2nd of March.
List this matter again on the 2nd of March 2026. The Learned Counsel for the petitioner. Huh?
My lord, can it be on 5th, my lord? 5th.
On 2nd there is?
I have a Shillong.
Huh.
5th.
On the 5th. List this matter again on the 5th of March 2026. We'll stop. The Learned Counsel for the petitioner has assured the court that the guardian of the that the mother of the petitioner, namely
Madhumita Malakar.
Now you see in your writ petition you have not written. You have not written the through part.
Represented by
Where?
the
Scroll.
court pattern also there.
Page 2.
Page 5.
What is the page 2?
Sorry, page 3, madam.
Page 3. Where is Madhumita?
Yeah, page 3 represented by her mother,
Where?
namely
Where?
Madhumita daughter.
Where?
Page 3 of the writ petition.
Page 3 is there.
Hindi
On the top.
dekha paana.
Top, madam. 2, it starts from bottom of 2, page 2. Iana Malakar,
No,
aged so and so, so and so, so and so.
Who Malakar?
Iana Malakar. Inaya Malakar. Yeah. Oh,
Ye Bhagwan. I would have passed orders in the wrong place. Huh? Ah, my God. Yes, list the matter again on the 5th of March 2026. The mother and natural guardian of the petitioner, who is a minor aged about 13 years, shall file an affidavit before this court that the pensionary benefits, pension and pensionary benefits released to the minor child shall be deposited and accounted for in an account to be maintained in the name of the minor daughter. She shall also specify in that affidavit as to the manner in which any expense, if required, to be made for the betterment of the child is proposed to be done. Full stop. This court notices that the custody of the minor child was with her deceased father. Full stop. Since the mother of the child now remains her only natural guardian, comma, and she has approached this court praying for the benefits towards the, she has been assisting the minor child in approaching this court, comma, Mr. H. Gupta, learned counsel appearing for the Railways Department, has submitted that the department would not be averse to making the payments in favor of the minor daughter, since her entitlement is not disputed in any manner, and the only anxiety in the mind of the railway authorities was the misuse of the aforesaid benefits, since the mother of the petitioner was not given the custody by the family court on an earlier occasion. Full stop. On the 5th of March 2026, Mr. H. Gupta, learned counsel, shall place before shall be supplied with, on or before the next date fixed, the respondents shall supply a bank draft of the amount to which the minor petitioner is entitled to, along with the final pension payment order in her favor in accordance with law and her entitlement. Full stop. It is made clear that in the absence of the financial benefits in the form of the bank draft and the final PPO being placed before this court would require the personal appearances of the officers who are connected with the disbursal of the pensionary benefits in favor of the minor petitioner. Full stop. It is noticed that no reason has been given in the. Have you filed the affidavit?
Yeah, affidavit they are fine.
What have you said in that?
They are processing. The affidavit.
That no reason has been given for the delay in releasing the amount to the minor petitioner whose entitlement was, is, and has not been stated to be in dispute. Now, don't come up with a sentence saying that the nominee was given as the divorced mother, therefore we cannot say it. Now, don't come up with something like that. We trust Mr. Gupta. Otherwise, the salary would have been stopped from today. It is only Mr. Gupta who has used his umbrella. In matters where there are some disputes, some doubt, we'll accommodate. 13-year-old minor daughter asking for a guardianship certificate. Not. Yes, a document.
My lord, just item 65 fixed on my lord Friday, my lord.
At the request of learned counsel.
Not this Friday, my lord. Next week Friday.
Petitioner.
66, my lord.
Again on
20.
But sir, since you have already made a request, we are keeping it.
Then on 23rd.
We do not like interference in the court proceedings.
Yes,
your hurry is of no
yes,
consequence, Mr. Sinha. This gives a wrong signal to the proceedings. We accommodate.
Yes.
We are not lenient. We accommodate. You want it when?
On 20 or 23rd.
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 Item number?
Item number 65.
Okay, done.
65.
No.
Yes.
Item number 40.
40, yes.
Sorry,
Also, item number 40 can see fixed on the hearing date. Because I have to take, because only 5 minutes that I have told my learned friend. These were put to my learned senior friend. So to him, hearing is that is. Lordship has heard the matter substantially.
Substantially, my lord has heard the matter.
Three queries were put to him.
Three queries were put. I've got two queries.
You
One-
have an interim in your favor.
No,
Because I'm out of service.
Here,
My basic relief is first to be reinstated and thereafter.
he has resigned. Now, my lord, on the other day when my lord first heard it.
Oh,
he-
yes,
because
he had a, disabled wife. Because he had a disabled mother or wife,
Yes.
he
Yes,
said,
yes,
I cannot
mother.
go, I resign,
Yes.
if I cannot be retained, I'm ready to resign and all. that.
Yes, resign, withdrawal, acceptance, now
Now,
the.
what instructions I have got it, my lord has stated that it was not within 3 months. Now, what circular we are having, or rules that we are having, the notice period is 3 months, and it has to be accepted within 3 months.
Hmm.
It is not beyond, and we have accepted it within 3 months. Next question my lord has sought for is whether he was given as a guardian, whether the bank has given tutored him. Not to go for resignation.
Not
That-
tutored, advised,
Yes, advised.
counseled.
Yes, counseling. That part also we have got it. First resignation letter, we have not accepted. We have given. We have told the.
We'll see we'll see on the day that we take it up.
Good.
Uh,
No, this matter has been
this
substantially.
substantially hurt part has been taken down on
Yes.
28/1, we get 30 days. It was done on 28/1, we get 30 days. It cannot be 5th of March.
A short point otherwise.
17th of March, or 17th of February. Huh?
No, the 17th, I am something, because immediately thereafter, or even before.
20,
Can
up to 26th,
19th,
26th,
19th or Thursday.
26th, 24th,
24th.
as a part of it. Huh?
Last matters will be there.
24th, you said?
Tuesday.
Tuesday, we have 18 matters already fixed.
Apply.
Huh?
Well, the petitioner, after serving for 39 years, 6 months, 15 days, he retired, my lord, on 31/12/2023. But his pension has not been released, though proposal has been submitted.
Pensionary benefits. None appears for the respondents on call. You appear? Yes.
PH department,
Mr. B. Pugasa appears for the
petitioner.
petitioner. Ms. Sensei appears for the accounting general. Yes, what do you have to say? Who submits that they have no role in the matter, full stop. Counsels for the other respondents are not present in the court. Affidavit has not been filed till date. Place the matter again on March objection. Twenty-fifth of March, 2026. By which time the respondents would ensure filing of their response to the writ petition. Regularization we cannot decide without the.
Made decision also.
The petitioner before Lordship is working as a multi-purpose worker. His wife is a teacher in Nalbari, my lord. The petitioner has been posted at in the place of a Nagaon, my lord, in Simona Basti. He prayed for
In your district, in the districts that you have prayed for,
my lord.
there are no vacancies available.
They are, my lord, filling up the vacancies, my lord, because I approached the Samul court, my lord. My case is not considering, they are not considering my case. In the meantime, my lord, they are considering the cases of other cases, other persons, my lord. I have the.
Anybody accommodated after
Yes.
filing of the writ petition?
Well, even after filing of the writ petition, they have accommodated one, my lord, in Nalbari, my lord.
Because he the contention, because it cannot be his right, my lord, then he has to be accommodated in this.
It cannot be also your sole authority that you will deny him and give it to everyone else.
But some other persons are also there. I don't know on what basis the other persons have been acquired.
Yes, get us a copy of this order of this government letter. You can take a copy. This ECF number 684-638/36 dated 29/1/2026. Mr. I. Secular and a counsel paying for the petitioner has submitted that the petitioner has sought for an accommodation in the districts of
Nalbari or any other nearby district.
Nalbari or any other district since his wife
Nearby district.
Since his wife is serving in
At Nalbari.
at Nalbari, full stop. The Learned Counsel for the Health and Family Welfare Department has produced an instruction saying that there is no vacancy available for no vacancy of multi-purpose worker male available in the district served by the petitioner.
Can I point out one thing?
In which
on 19/12/2025, Mr. Honorable Court directed the authority, my lord, directed my friend to produce the vacant, if the petitioner can be accommodated before in nearby district, my lord.
They are saying no.
No,
That is the decision.
Post fallen vacant on 31st December 2025. Another post fallen vacant on 31st January 2026.
Mr. Isakiel and the council submits that a post had fallen vacant, a post at Nalbari.
Not Nalbari,
Where?
in North Guwahati.
In North Guwahati, and another post
Rongia.
in Rongia had fallen vacant on 31st of December 2025 and
31st January 2026.
31st of January 2026. Mr. Boral and the council has released before this course instructions to the effect that there are no that the post which fell vacant on 31/12/2025 has already been filled up by the order dated 5/1/2 by the department's order dated 5/1/2026, and the post at North Guwahati was filled up by a transfer order dated 9/2/2026. It is the specific stand of in the instruction that both the transfer proposals were processed prior to the Honorable Court's order dated 22/1/2026. Full stop. The instructions do not reveal as to when was the process started, or was the process taken up even before this, or even before the petitioner had referred the writ petition, initiated the writ petition. Full stop. Mr. I. Secular Learned Counsel appearing for the petitioner has placed before this court an order dated 4/2/2026 by which one Musfaful Hussain, MPW within bracket M, working under the Udarbond BPHC, was allowed to work on attachment under the disposal of the Joint Director of Health Services Nalbari with immediate effect. This is said to be with the approval of the competent authority of the Health and Family Welfare Department. Mr. Bora further makes a submission that it is not the right of the petitioner to seek his posting to any particular place, and it is solely the discretion of the administrative authorities to post any person anywhere without considering the requirements or prayer made by the petitioner.
And in fact, my lord, once his prayer has been considered, and thereafter this speaking order that he has challenged in this petition, page 73, that has been passed. And
he has further submitted that earlier the prayer of the petitioner for a spouse posting had already been considered, and the speaking order rejecting his prayers now is already on record, which is under challenge. Full stop. Mr. Borash, and before this court,
there is the observation, kindly note, my lord, in that speaking order, there is the observation there. Whereas, however, if the petitioner is able to arrange a mutual transfer with another eligible MPW from Nalbari district, the same may be considered.
Mr. Bora has also read out the contents of the speaking order. On the next date fixed, Mr. Bora shall apprise this court the contents of the letter number ECF number 684-638/36 dated 29/1/2026, and also the copy of the approval of the competent authority of the Health and Family Welfare Department allowing Musfaful Hussain to work under attachment in the establishment of the Joint Director Health Services Nalbari, who has been brought on from the services from the establishment of the Joint Director of Health Services, Kachar, Bhagwan B.
But otherwise, my lord, it is not
PHC.
relevant with this case, my lord. Because
Mr. Bora has submitted that this order is not relevant with this case, yet this court deems it fit to have irrelevant documents
no,
placed
my
by
lord,
order.
what I am submitting,
Please
my
say.
lord, the speaking order says that, my lord, the place where the petitioner is serving, the person is necessary there. So if he can arrange someone in his place, then mutually, because it is matter.
Raise this matter again and give us a convenient date, sir. We are at 4:35
Yes,
and
my
others are waiting.
But otherwise,
We are
the
beyond the court time.
Next week, madam, if possible.
It is to his convenience. He has to produce those documents.
yes, my lord. After 10 days, my lord.
Choose a date, sir.
Please, label. On 25.
On 25th, my lord.
25th of February
25th.
2026. Yes?
23rd or 25th.
We'll give you a PC if you request for one. But
I-
accommodating all the advocates, fills up our
27,
list.
if it cannot be on 25th, let it be on 27, my lord.
27th of February 2026.
Obliged, my lord.
Lordship may fix this method last week of this month, any date. Lordship.
Last week of this month is a bit difficult. We can have the second week of March possible.
First week of March, Lordship, they have retired employee, Lordship, not getting salary.
We'll have it on the 13th of March.
Obliged, Lordship.
Paucity of time, 13th of March. Mr. So-and-so appears for petitioner, Mr. So-and-so appears for the respondents. You give your name in writing
Yes, sir.
and the respondent number.
45.
In this case, we have filed one review application as against the judgment which the petitioner is relying.
This is a writ petition.
Manor.
This is a writ petition.
Manor. No, the order on which they are relying, Annexure 2, the order passed in WPC number 4850/22. That is, we have filed a review petition and which is yet to be listed.
Issue is not like that, my lord. This
Issue is the lack of time.
Hmm.
Today, can we pass any effective orders today?
a date may be given, man. And by this time, my lord, they may file affidavit in this case, man.
16th of March 2025. Respondents should be at liberty to file their response to the writ petition.
Now, let's see the promotion of the petition. Lordship.
Promotion,
Promotion, Lordship.
23rd of March. They are yet to file the affidavit, 25 matter. 23rd of March,
Lordship.
to file affidavit in opposition by the respondents. Yes.
My pleasure.
Here is the, well, according to the last order, we have filed the additional affidavit, but in
The additional affidavit stated to have been filed by the petitioner is not on record. List the matter again on the 3rd of March, along with the additional affidavit filed by the petitioner.
3rd of March, holiday.
2nd of March,
Oh, no, 5th,
5th of March.
5th of March. Okay.
Yes. Now does any admission I call it? One admission. Yes, any urgent orders to be passed. Fixing of dates, we will get it done. Orders, anything urgent, any orders required to be passed. 60, yes.
Lordship, as part of, we are required to file on affidavit, Lordship. Affidavit ready. We have to send our letter for swearing laws. The swearing sign is not been done.
Mr. Burua, learned government
Only
advocate
one.
has submitted that the affidavit has been prepared and will be filed within the course of this week. Leads the matter again on, what is the matter in urgency, no? 16th of,
But we have already paid.
16th of, huh?
We have already paid that.
On the, then there's no problem. 16th of March 2025, 2026,
Not supply.
along with the affidavit, yes.
In this particular matter, probably government
Yes,
is supposed
that
to come with
report.
the necessary instruction.
We have obtained the instruction.
That was last time also given, but it was supposed to be filed in the form of an affidavit.
No, there was no such direction to file in the form of.
Affidavit, okay.
To produce the report.
Selection
We
committee.
have, and the principal has now appeared there.
Yes,
That's
tell
point
us.
number 3.
You want to file your affidavit? Why was it not done till now?
I filed my wakalatnama yesterday.
Yes, no, why was the principal not having, did you ask her or ask him?
Yes, I.
What was the cause of the delay?
Instruction I've obtained, your lordship, the principal had summoned the selection committee to take cognizance of the fact that the order of the High Court. And after that, there was a meeting of the selection committee and a report had been given. And in fact, the principal, who is the current principal now, he had been appointed in the year 2025. In this case pertains to the year 2022. So he did as per the direction passed by.
So what was the last position? The marks which are not given, is this the case? Where you are not given.
The DAG guideline is there.
Teaching marks and it was sent back and the same name has again come back.
Again come back. They are repeating the same thing.
Okay, we'll take it up on the 17th of March on a hearing day.
17th of March.
We don't have hearing dates before that.
Can be a little bit early also, because again on the 17th of March, they will ask for the filing affidavit.
No. For disposal.
For disposal.
For disposal.
Okay.
Whatever
in between
affidavits
that,
are
they have
required
to
to be
exchange,
filed,
yes.
have it filed before that. Yes, sir. We'll have it on 17th of March.
Yes, sir.
Any affidavits required to be filed are to be filed before that date. And any affidavit proposed to be filed after that date would incur costs of rupees 5,000. And without the affidavit, presumption will be drawn that adverse presumptions will be drawn. Yes. Mr. So-and-so and a counsellor has entered appearance for the respondent number 3. And seeks some time to file the response to the petition, full stop. Place this matter again on the 17th of March 2026. The respondents may file their affidavit on or before 10th of March 2026. Petitioner would be at liberty to file their response thereto before the next returnable date. It is made clear that if no affidavit is filed on or before 10th of March 2026, the respondents would be liable to pay costs of rupees 5,000 for delaying the adjudication of the matter.
Endeavor should be there, lordship, for disposal. Endeavor should be there for disposal of the matter.
That is why a hearing day.
Deeply obliged.
Have you seen a lack of endeavor, sir?
No, I'm not on that, lordship. Some observation is required for them.
Lordship, day before yesterday, Lordship heard this matter and directed to obtain the instruction. This is regarding salary. Mr. Anjay Katu, last order, my lord. I think he's not getting.
Mr. Anjay Khatoni, we missed him by a hair's breadth. We saw him some time ago.
Lordship, fixed the other day, convenient date for today.
6th of March?
The salary is not.
Salary?
Yes, from March 2015. Illegal irregular teaching. Already affidavit is filed by them, Lordship. Lordship only.
From 15, you have not got the salary.
Yes, Lordship.
2024, you decide to come to the court.
No, Lordship, long back.
9 years.
Thought that, Lordship, is possible.
Shorter than that. 2nd of March.
Yes.
2nd of March.
Madam.
Allowing Mr. Anjay Khatoni to appear. Yes.
Lordship, a short time is required to get the update in instruction.
No,
That area salary part.
that censure.
Yes, Lordship. I have challenged the penalty.
Lordship, the area salary part, Lordship has directed me.
Oh, yes. Has he been paid?
My instruction, there is some miscommunication both by them.
Has it
petitioner
been
has,
paid?
no,
No, is
Lordship,
it
the-
disputed? Is it
no,
disputed?
no, the process is there. Lordship may take it after a 10 days time, Lordship. I
No,
can
but
give the-
anything that happens now goes to 18th of March. Have all the confusions cleared?
Yes, Lordship.
At the consent of the learned counsel for the parties, list this matter again on the 18th of March.
Can I
The Mr. B. Chaudhary would still be under the obligation to get the instructions
Yes,
sought for by the earlier order. Okay?
Lordship, Lordship, I may be allowed to file a reply affidavit against the affidavit opposition filed by responding by to your lord. A week's time will be allowed.
Mr. Muzinda raised for an opportunity to file the affidavit in response to the affidavit in opposition filed by the respondents. Prayer allowed list again on 26th of March 2026.
Deeply, much obliged.
Sir, sis.
With your lordship, they have complied, your lordship, and my prayer was rejected. So first we
That is said compliance.
liberty, lordship.
Mr. DJ Das, learned counsel appearing for the petitioner has submitted that the order passed by this court has been complied with. However, unfortunately rejecting the case of the petitioner, full stop. He praised the liberty to assail the order passed in compliance of the orders of this court, full stop. Granting such liberty, if the contempt case is closed as complied.
Much obliged.
We'll retain that word unfortunately.
Lordship.
We will retain the word unfortunately in the order, no. Yeah, unfortunately to decide you.
Much obliged.
Yes.
I am appearing on behalf of K.R. Patgiri.
Ah,
The matter is pertaining to area family defense, sorry, family. and
there is
family-
some noting in the earlier order that for mediation,
Yes, but not settled here,
not settled.
not settled. Matter
Okay.
may take the matter for admission. And 53 is similar item. Similar, from, written from the. mediation
51 and
side.
43, 53.
51 and 53, yes.
50 and 53 list again on 20th of March, 20.
20 for
20
admission.
March for admission.
For
Since mediation has reportedly not succeeded.
Not succeed.
53 to be solicited. Ah, different photograph. Happens. You filed your affidavit.
No.
You would not like to.
Yes, madam. Sometime.
Mr. B. Talukdar, the council appearing for the education department has sought for accommodation to file the affidavit in opposition. List the matter again on 27th of March, along with the affidavit in opposition proposed to be filed.
Okay.
This matter went for mediation failed, Lordship.
Mediation failed because you were not ready to settle the matter.
Because Lordship.
Oh, we are not
This
saying
was-
so, report is saying
yes,
so.
Yes.
Report
Lordship,
is saying it failed because you did not,
Area salary and GPF and along with
they don't want to give it.
MSc fields. Lordship, this matter will be fixed for admission.
Lordship, my colleague, Lordship, he has asked me to submit this.
Who?
Accountant General, Lordship, they don't have any say in this matter, Lordship.
Okay.
Only with regard to.
That, give it back, we don't need this, give it back.
Yes, Soma.
Okay, heard Mr. Swenson on a council petitioner. Also, Mr. Swenson appears on behalf of Mr. B. Sharma, and a council for the respondent number 6, full stop. Place this matter for admission on 20 March 2026. Since mediation has failed, that one sentence, since mediation has failed. None appears for the petitioner call. Since perhaps the court hours are over, list this matter again on the 20th of March 2026.
encourage them kindly be granted to file counter affidavit.
Distribution Malad Council paying for the respondents has paid for 4 weeks time to file the affidavit in opposition. The amended cost title required to be filed has not been filed.
Yes,
till
my
date.
lord, we will be filing it soon. But 1 week time may be granted, my lord.
It should be a matter of 3 minutes. Earlier cost title,
Only
one
to
name
delete-
added,
delete.
printed and given.
Not
3
fair.
minutes.
Apologies.
We have just noted that the cost title has not been filed. You file. List again on 25th of March 2026.
Obliged.
None appears for the none appears for the petitioner on call. You are for PNID.
Worship Mr. Kekmo is appearing as additional in this matter.
None appears for the petitioner on call. Perhaps since it is beyond the court hours, list again on. Is there any urgency in the matter? What is the matter?
There be, petitioner has retired, although he has no file on suspension. He is seeking the subsistence allowance.
There is some urgency in the.
No, he has been receiving the subsistence allowance as per our instructions.
On 13th of March 2026.
Obliged, Lordship.
Okay.